We're live, people. How is everybody doing? Okay, standard intro. What's up, peeps? This is going to be back in Montreal, so I have regular internet, and we shouldn't have any blackouts. We shouldn't have any audio problems, but if everyone could let me know if the audio is in fact good and if you see me clear and glistening. I exercised about an hour ago in this unair-conditioned house. Oh my gosh, I was dripping, not that anybody really wants to know, dripping sweat, and feel like an episode of The Simpsons, not The Simpsons, Seinfeld, where I'm still sweating because I didn't take a cold enough shower. Okay, well, we already have 3 super chats, so before I do the standard intro rules, I'll just get to them. James Scott, what are your thoughts on the detention in Portland of Mr. Pettibone by federal agents? Is this lawful but awful? I'm not sure, don't have an opinion, but we'll ask Barnes when he gets in. Mark Watson, Viva. Judge Sullivan is complaining the Pike was guilty of treason and perjury and should not have been set free. If nobody saw that video that I put up yesterday, catching a pike off the drone, it was not quite as invigorating and shocking as the first time I did it 4 years ago, almost to the day where I caught the bass. But my goodness. And for anybody asking about the legality, I'll get to that in a second. Nuvi says, Viva, you should interview Mark and Craig Wasserman, pot brothers at law, funny and educational. I would be totally game for that. I mean, I've seen their ads and I've seen some of their stuff, and it's great. The pike. Before Robert gets here, Robert's not yet here. We'll do the rules of the game and the anecdote of this fish. I caught a pike off a drone. I was trolling a jitterbug and fishing with a drone, not the way, some people do with a worm and they go into a pond and pull out a little sunfish, and not the cheating way of like hauling your lure out way out into the water where you see the fish, dropping it down and then reeling it on the rod. I tied like 10 feet of fish, well, maybe a little more, 20 feet of fishing line to the drone and used a jitterbug to troll the jitterbug on the water to get the proper action on a jitterbug. And if anybody doesn't know what a jitterbug is, it's a floating lure with like a cone sort of silver piece of metal on its nose that causes it to wobble on the water. And you've got to bring in a jitterbug at the right pace so that it wobbles, but it doesn't skid, and so that it actually has action. I hooked a freaking pike this time, and you capture the strike, capture the pike leaping out of the water like an acrobat, and so I captured the whole thing on video. I used up 2 gigs of data on my phone to make sure I backed up an insurance version of the video on the internet. And people were saying, that's illegal, blah, 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 especially coming from someone who faulted Jake Paul for uploading video of him committing a crime of whatever he did. So here's the thing. It's an interesting thing. I've been joking for a while that the drone laws in Canada were amended to prohibit transporting a living animal by drone. And I sort of joked around that was the response to my previous video. Truth and jest, but the joke is I'm fairly certain that provision of drone laws is intended to regulate transportation, for the purpose of like Amazon type deliveries. There are specific states and provinces which specifically outlaw the use of drones in hunting and fishing, and that is more for corralling animals, locating animals that are at a distance so it can procure an unfair advantage to tracking and hunting. There are 4 provinces in Canada that have outlawed this specifically, and a number of other states. Vermont in particular specifically talks about not using a drone to fish, period. Thus far, as my reading goes, in Quebec, we don't have the drone laws for hunting. This isn't hunting anyhow. It is not corralling or identifying or procuring any unfair advantage. On the contrary, I think this procures no advantage whatsoever. It is all disadvantage. And so I'm fairly certain it is actually not illegal until such time as they specifically address it. And I just hope I'm right. I think I'm right. What do we got? Oh, we got Justin Trudeau's back in the house. In Canada, the PM can identify as, I'm not going to read this, I don't want to get in trouble, depending on his day. We have a prime minister who's now, I've been intending to do the vlog on his We Charity scandal, but one has to know what one is talking about before embarking on that discussion. And the corporate structure of the We Charity is itself something that is difficult to understand, and you have to make sure you get it right. Okay, so Robert's not here yet, but he is coming. So these are the rules. First of all, welcome. Nice to see everybody again, virtually speaking. Share the links because sometimes notifications are slow for the live streams and people get them 12 hours later, which is not necessarily good. All the super chats, I'm going to do my best to get to the super chats. If I don't, I apologize in advance. I'm going to try to get to non-super chats as well so that it is not just, I don't want to use the word pay to play. That's got some bad connotations, but to spread it out and be fair to everybody. So that's it. And now we've got some subjects. What are the subjects? DJ, what up? DJ's in the house. Okay, I just made that up. No, Jake, it's not a question. First of all, it's not black. It was the other word of which, people. It's that you do, whether you like it or not. There I say you're playing within certain paradigms, and you don't need to attract the wrong attention for the wrong reasons. And certain people can say whatever they want in here, but I'm not I'm not trying to walk on eggshells, but sometimes it feels that way. So what is on the menu for tonight? Thoughts on Washington State versus Defense Distributed reads like a Ninth Circuit mess. Caleb, I don't know about that. We'll see when Robert gets here. Maybe he's going to know. And Fractal says, what are your thoughts about the judge on the Jeffrey Epstein Deutsche Bank case? Okay. So also that I'm not going to talk about just because there's not enough information yet to even have a sensible discussion. There's too much unknown, so little known, which allows for massive amounts of speculation. But it's crazy news. I mean, there's no other word for it. It's when lawyers and members of families of judges and judges, when things like this happen that's like next level madness. When is Robert's show coming back on Band TV? I didn't know he had an issue with it. Barnes seems to know everything. Barnes knows a lot. And let me just actually message him and let him know that we're here. We're live, when you're ready, smiley face. Okay, so on the menu for tonight, there's so much. First of all, Missouri couple charged with brandishing firearms. It's I just tweeted out, it seems like people are going out of their way to make bad decisions to make matters worse. We're going to talk about Sidney Powell's response in the Judge Flynn case. Oh, we had so many things. I have to get my list of things that we're talking about. Ghislaine Maxwell bail, and now that fits into the other topic. Portland riots lawsuit, mask discrimination. The mask stuff is getting madness as well. Sidney Powell for Attorney General. see if that works. The governor said she'd pardon them. Fat Spiel. So we'll get into this when Robert gets here. But this is why Twitter makes things worse. Politics makes everything worse. But that's coming on a shirt sooner than later. Twitter. When you have like Mayor de Blasio tweeting things which could be deemed to be pressure tactics, and the same thing goes for the President Trump as well. This is not a pass for one and not for the other. When people tweet about ongoing affairs, it creates pressures, expectations, and arguably, I don't want to say corruption, but arguably it gives people an indication as to what the powers that be want them to do, and it also creates conflict when the people who are making decisions now might have an interest to defy what the powers that be want them to do. So people tweeting that they're going to get pardoned before the DA has even pressed charges creates this dynamic where the DA might press charges out of spite and then claim that the pardon is political. Everything gets ruined by politics, and the game of tweeting pending issues creates problems as well. Carson Large says, my wife is a Chinese citizen that needs to go back for her grandma's funeral. She expressed support for Hong Kong independence. Would the U.S. government get her out if she gets arrested? So it's interesting. I had a discussion with someone about this. First of all, no legal advice. I don't know. I mean, and this is the crazy thing, that they have these laws which can apply to people who defy the Chinese authorities even outside of China. So what happens if they go into China? A lot of people have this as a real issue. Reporters, for one, and who knows what the answer is. Habeas corpus is a great principle, and when you travel to countries without the rule of habeas corpus, you're running a risk of something. And I don't know. It's a risky thing. Who knows? They find a tweet once you're there and say, well, now we're detaining you. And then it's one thing to appeal to your local authorities to intervene, but that doesn't always do very much. So, I mean, that's interesting. Is Robert coming? Robert is coming. Robert is reliable like a Timex clock. I just have to, keep everyone entertained until he gets here. So that's what's on the menu. But we can start talking about the Missouri charges being filed, and you read the press release coming from the DA, and I wish I could pull it up, but I can't pull it up. The press release doesn't make any sense. Talking about how they're pressing charges because they value the First Amendment and they have to balance it with the Second Amendment, but the DA just pressed charges against someone who violently assaulted peaceful protesters, as if to suggest that what those two people did, ostensibly and until proof to the contrary, to protect their home from what was arguably, if not definitively, at the very least, a threat to them, equating that to a violent assault on a peaceful protester. You see the sort of dynamic that the DA is, I hope I'm saying the DA right, is trying to set up in the justification to press charges, which a lot of people are going to find shocking. Let's see, we've got Joshua Mata says, always great listening to you, makes for both informative and entertainment on these legal issues. Never in a million years would I have thought that my YouTube career would come full circle back to law, but it seems to have. Viva's new sponsor, Timex. I can't wear watches anymore, so there's no point in even entertaining that. What do we got? John Brett says, Brett Schneider says, always a great show, Viva. Was there a Saint Jean Baptiste Day celebration in Old Montreal this year? We had some fireworks, but they were uneventful fireworks. For the rest of July, our bridge is going to be a rainbow-colored lights because we've had lights installed on the bridge to pay tribute for the first responders. Yeah, where is Robbie? Maître Barnes, as we say. Let me check my Twitter. I'm sure I sent him the link this time. Here's the stream. Okay, I did yesterday. So he's got the link. He'll be here. Okay, let's take some questions until he gets here. Oh, how did I not miss anybody? I did not miss somebody's super chat already. You missed my super chat? You've missed my super chat. Stephen, if it did, put a question down there and I'll get to it. Let's see. I'll get to some questions while we do this. Can we fight the bullplop Montreal mask bylaw? I won't call it a bullplop bylaw. It certainly is drafted in such a way that is. So this was the vlog I wanted to do today, but I couldn't get to it because I couldn't find the actual regulation, but I found it. We have recently implemented mandatory masks. And the funny thing about masks is I think everybody can agree that they probably do something. I don't think most people are going to say that. I think the argument that they do absolutely nothing. I mean, there's a reason why people say cough in your arm if you're going to cough. I think they arguably don't do. They definitively do something. The only question is how much do they do versus the imposition that the government is imposing, and whether or not it's proportionate and constitutional. So I got my hands on the regulation, and the regulation says you have to wear a mask if you are indoors in a public arena or partially covered, which is, Robert is here. Good. Now I'll finish this. You have to wear the mask if you are indoors in a closed or partially roofed covered area. Exemptions, if you're under 12 years old, if you have a medical condition, if you're eating or drinking in an area that is destined or designed for eating or drinking. So in theory, watching this video of this guy get arrested and pepper sprayed in Tim Hortons because he wasn't wearing a mask, some people call him stubborn, and he might very well have been stubborn, wrong. He might be whatever. He might be all the names everybody's calling him. He might have had a medical condition and didn't want to divulge it. He might have misunderstood the law and thought that he doesn't have to wear it to order if he's going to sit there and eat and drink his coffee. And it leads to him getting pepper sprayed, manhandled, and arrested. People handled, person handled. Okay, let's get some super chats before they get out of hand, and then we're going to bring in Robert Barnes. You are going to have to be a spokesman for drone manufacturers. No, you know what? I don't even like the fact that drones are made in China, and I don't like the whole thing about where they're made and what the risks are of information being relayed to China. All I know is that if the information is being relayed from my DJI drone to China, they are getting beautiful views of a lake. All right, Ginny says, I long for a world where we all approach life with the same awe and wonder of Ethan catching his first fish. If nobody saw that, We made it onto Fox News, and I think that we were actually on Fox Friends or the Five talking about it. Thank you very much, Jenny. That was a glorious moment as well. The American right never holds the left's feet to the fire. This DA will stir up the left base with these charges, and when they fall apart after the election, the right will be zero. We'll do zero about it. Zero. We'll see. I think even the left are going to get angry at this because I think even the left are going to get angry with this. That's what I think. Sarwaz, okay, let's do this. I see Robert. I think he's got something in his mouth. Yes, he does. Madame Moncook says a judge that took the Ghislaine Maxwell case had assassin who shot. My understanding, the judge in that case was the judge overseeing the class action against Deutsche Bank, and one of the individuals or the guilty culprits in that was Jeffrey Epstein. That's my understanding. We'll see if Robert probably knows more than me. And when I say probably, I mean definitively. I think I missed some. Have you read any of Bob Lawball's law book? No, I haven't. I can answer that quickly. I have been lucky to get some books on Audible, which is the only way I can read a book these days. How do you legally define the difference between peaceful protesters and rioters? Okay, let's see this before I miss one. Sorry about this, guys. Okay, I missed it. My apologies. Bringing in Barnes to the stream. Let's see. I see something different about Robert tonight. Robert,
back in Vegas.
Are you on mute? You might be on mute.
Let me check.
Audio is a good start.
I should be here. No.
Everyone can still hear me, right? Well, I didn't hear that Styx Hexenhammer was doxxed today. I'm going to go look that up, interestingly enough. Let's see if Robert's... Uh-oh.
Check. No?
Nothing. Huh. We might just go unplug and... go old school. Is the screen completely black for anyone else? Hold on. Can we see if we can hear Robert? Robert, maybe it's me.
Yeah, because my system says I'm here.
It may have been me as an idiot because I might have had my computer.
No problem.
Okay. Thank you, everyone in the chat, for letting me know I'm an idiot. All right, Robert, how you doing?
Good. I got the Red Sox because baseball season is back up and going.
That was the only thing I noticed that was different. That and that's not what its color is. That lavender.
You're asking the wrong guy. It's a seersucker, but it's red. That's what I know. So it's a slightly different seersucker than my typical light blue one.
Well, it is beautiful. It is the Boston hat, Boston Red Sox.
Yes.
Okay. Awesome. And the cigar as usual. And we got we got Jeremy Rutledge says 5 for Viva to buy some fishing supplies for his kids and 5 for Barnes for the cigars. Where do we start? Do we start with? Let's start with the one that we're going to spend the least amount of time on, and I for obvious reasons. But what happened in the news today with the judge and her family? People are saying that that the judge was assigned to the Epstein case. This judge in particular. Do you know what her relationship was to anything of the Epstein case?
The Deutsche Bank, what you referenced, the investor class action against Deutsche Bank for not flagging his transactions sooner.
And it's a class action against Deutsche Bank. My understanding was that there were a group of clients who were the object of the accusations against Deutsche Bank, so it wasn't strictly and only Jeffrey Epstein?
That's correct.
So they're suing a bunch of, I presume, clients of the bank or investors are suing Deutsche Bank for not having vetted transaction. What would be the basis?
In essence, it's not doing KYC, not knowing your customer. So not doing due diligence in certain transactions, not flagging them. How exactly it hurt the people that were suing was less than crystal clear. It was sort of an extrapolation that it did damage to Deutsche Bank's reputation, which in turn diminished Deutsche Bank's stock holding. I'm not sure that's quite accurate. I mean, some of these banks have been making money, laundering money for a long time. Julius Baer just had a record season this past quarter. And Julius Baer, a Swiss bank that chooses not to have any U.S. bank relationships for a reason, has been accused of being a money launderer for a long time. Other banks too. So I'm not sure. The legal theory for the suit did not strike me as the strongest legal theory. It looked to me like just a way to embarrass Deutsche Bank and get some cash out of it. That's how I read it. I didn't read it as a high quality suit. And I still don't believe there's any connection proven as yet It didn't strike me as it makes sense. Why kill the judge? How does killing the judge serve anybody connected to Epstein? Epstein's not a party to the case. The economic transactions are already known. There's no way to like hide that in terms of what Deutsche Bank did or did not do. So it was not. I think she'd just been assigned the case 4 days before. So I get why people are very hyper aware of anything connected to Epstein, but I'm not seeing any connection that would explain why someone would kill a judge. Unlike in Latin America and other parts of the world, Europe, where judges are the prosecutor, then that would make sense. That's not here in the United States. So I suspect a different story will come out ultimately. I suspect someone either may not even be connected to the judge. It might be. It might be disconnected. I mean, the person that was shot was her husband, who was a lawyer.
Well, that's the thing. Maybe people don't know that her husband was a criminal lawyer. Yeah. And, even in Canada, criminal lawyers, not oftentimes, but unsurprisingly frequently get caught up in things.
Yeah, absolutely. I mean, I've been threatened all the time, both criminal cases and civil rights cases, not from your client. It's from other people who think they'll be exposed by the work you do. So that's a more likely explanation. Doesn't mean Epstein has no connection. Doesn't mean that the judge wasn't ultimately the target. It's just a little odd to show up, shoot the husband, shoot the son, but not shoot the judge if the judge was the target. That seems peculiar to me. And to be well prepared enough to show up as a FedEx guy, but which is that's the sign of a hit, professional hit, but not know that the judge wouldn't answer the door. I mean, so I get when people see Epstein, judge, death, they rush to conclusions that it's Epstein connected because of everything crazy about Epstein, and justifiably. But I'm just telling people I don't think that's where this particular case will end up.
Anyways, there's so little known. It's just the type of thing where it's better off withholding any sort of affirmation or statement, especially the ones that are going to be more on the edges of the extreme, and just wait for the news and then put things together as that happens. Okay, we'll just get this one. Fafuin says, with the defund the police going on, how would Miranda work when they send social workers or anything else besides sworn officers? How would arrests work?
They wouldn't arrest, and so there would be no Miranda application. It's some of the implications of all this. If you bring in people to do non-custodial work, then what happens with the information they give that non-custodial officer? Generally, it's not subject to protection. It's not subject to suppression. It can be fully disclosed. So so I think that now as a whole, I think a lot of these cases are they don't really belong in the criminal arena. The ones they're talking about shifting to social workers. We definitely over-criminalize in the United States. That's just the reality of it. We have one of the highest incarceration rates in the world, have for a long time. And a lot of those people that are in there purely for drug use. That doesn't really make sense. These are not people who are threats to anyone but themselves. And so I'm not a big fan of locking people up who are perceived as just threats to themselves. That's a dangerous path once you go down it. Once you start saying the state can lock you up if somebody from the government concludes you're a danger to yourself, well, where does that end? We should mark the line if you're a danger to someone else, period. If you're not a danger to someone else, there shouldn't be any denial of your physical liberty. That's not what the law is, but that's my view. So a lot of these cases are cases that do not belong in the criminal justice system and are not solved by criminal justice remedies. We should focus on violent, dangerous criminals for our criminal justice system, and we could dramatically increase some of their sentencing exposure where appropriate if we're not overcrowded with a bunch of nonviolent people stuck in our jails and prisons.
All right, interesting. I'm just going to bring this one up because I think the point was to scare the judge. If you do that, if you kill the judge, you just get.
I get the logic, but play that out, everybody.
Yeah, if the judge is going to accuse herself now, anyhow, you're just going to get another judge, one with the other. I presume the judge could, in theory, say I have to take leave, so find another judge. Anyhow,
one the judge could recuse themselves, and if that was the goal, then I suppose so. But why? The judge has been on the case 4 days. How does this have any impact? Again, all the information is going to be known. This is the Deutsche Bank case. This is about their not doing KYC based on facts already known. This isn't about unknown facts. They're not trying to discover facts they did not know. So I don't see exactly. I haven't yet seen a compelling case. I get where people want to connect it because of so many weird things happening with Epstein. It's just logically just not there yet. There definitely isn't the evidence to support it, and I don't understand what So the goal was I'm gonna scare you by killing your husband, killing your son. How's that going to scare you? You've already killed them. So what's the objective? I mean, I'm yet to see a real logical explanation for how this is supposed to work. I'm going to scare you by doing the very thing I would threaten you with, by actually already doing it. Well, once you already do it, there's no more threat.
I guess one argument is going to be it's going to be a deterrent for any other judge who gets assigned the case or gets assigned a future case.
I get the lot, but what do they think the judge is going to do? The judge just rules on evidence and rules whether to dismiss the case. The judge doesn't determine anything else about the case. It's a jury case. Jury determines it. And the facts are all done by discovery between the parties. So that's where I'm not getting. As a general rule, the only time you see judges targeted is when the judge has issued a sentence or threatened to issue a sentence or refused to dismiss, say, against an individual. That's about it. And because in the American court system, if a federal judge dismisses, it just gets appealed frequently. Unless it happens at the jury trial itself. So it's not in America, other than bribing a judge to make a certain evidentiary ruling or issue a summary judgment, and then you hope it somehow gets affirmed on appeal. It's just not a very effective mechanism of contaminating the justice process. You can try to intimidate jurors. That occasionally happens, but even that's pretty rare. The corruption in the judicial process in the United States, in terms of quid pro quo kind of corruption, doesn't really happen with judges much. It happens with jurors, potentially, but it really happens with prosecutors and with witnesses. That's where the corruption, because they're the ones who wield the power in our system of criminal justice. The judges don't only have a little bit of power. Frankly, you can have a judge like Sullivan who drags it out forever. But that should be an example. There's a judge who doesn't like what's happening, doesn't want it to happen, and he basically legally has no power to do anything about it. So you can get judges who make your case harder in terms of jury instructions, in terms of evidentiary rulings, things like that. But all of that is subject to appeal. So are you going to appeal? Are you going to bribe everybody? Are you going to bribe the 3 random judges who get assigned to the Court of Appeals, 5 random judges to the U.S. Supreme Court? So you have things like the Pelican Brief, but at least that was based on a realistic premise by John Grisham, which was the case is already pending before the Supreme Court, and you already know you have 4 with you or 3 with you. You just need to get rid of these other 2 because the president will appoint your replacements. That's actually at least that's a realistic premise for something happening in the U.S. justice system. A judge randomly getting assigned and 4 days later her family being killed as some sort of strategy to impact the case is just not very logical, at least by anything I can see. Doesn't rule it out, but at this stage, it's not. If I was an investigator, it's not where I would instinctively look.
I guess okay. I mean, and that's it. Everybody's going to have the theories, and the problem is when there is certain elements that come together, you just can't. You could chalk it up to coincidence. It might very well be, but you can't even call someone unreasonable for thinking it is not a coincidence. So,
yeah, and I don't consider it unreasonable. I just consider it less likely.
Okay, let's start now. It is 28 minutes in. Let's start with the first subject. The Missouri couple charged. What exactly are they charged with?
So they're charged with brandishing a weapon and a threatening. It's actually not even called brandish. It's called exhibit. Exhibit a weapon in, quote, an angry or threatening manner. And for which there are justification defenses under Missouri self-defense statutes. Though the Missouri self-defense statutes were actually written for actually committing violence. They weren't written for someone who never even commits it. So there's some question about how the statutes are going to interact, because this statute has rarely been utilized in Missouri's criminal jurisprudence. And I think there are serious problems with the statute as written. One, I don't see how exhibiting a weapon, period, can constitute a crime under the Second Amendment to the U.S. Constitution. I think it has to be a separate, you threaten to assault someone with a weapon. Okay, maybe that, but there was nobody who felt that way. There's nobody apparently who testified to that effect, because that's what they're just being charged with: exhibiting a weapon, no victim. It's like the Amy Cooper case and other cases where they're bringing prosecutions where there's no victim, or where the purported victim says, "I don't want the prosecution to go forward." They're just saying, "Hey, if you go out and you exhibit a weapon, and we decide as a prosecution that it's, quote, angry or threatening the manner in which you did it, we can prosecute you." I think the statute on its face violates the Second Amendment to the U.S. Constitution. So I think it also violates the Fifth Amendment to the U.S. Constitution for due process purposes, because it's so vague. Define angry. define threatening.
So well,
the statute, by the way, does not define either.
And as a matter of law, so they're going to plead not guilty. Well, okay, as a matter of law, how do you then attack that? Is your defense unconstitutionality? Like,
oh yeah, you move to dismiss right away. The statute's unconstitutional on its face. Unconstitutional as applied to these defendants. Unconstitutional first because it fails to define the word angry or the word threatening. Second, unconstitutional because those words are void for vagueness. And there's the rule of lenity in the criminal justice process in the United States, which says any law has to be interpreted in the way most favorable to the criminal defendant, because it's that defendant whose liberty interest is at stake. But here, the word angry or threatening is not defined, and it's clearly too vague. And here's the classic void for vagueness case. It went up in a disorderly conduct curfew case involving gangs. The U.S. Supreme Court, Justice Breyer said, look, if the law is such that different police officers could interpret it differently, then you have an unconstitutional delegation of discretion from the legislative branch to the executive branch, and that's the definition of being void for vagueness. It has to be so specific that a cop on the beat doesn't have any doubt about how it's interpreted. Angry? I don't even know what that means.
Well, the other thing is,
here's another variation of that. The way to do it is defamation. Could I sue someone for saying Barnes is one angry lawyer? No, I couldn't. What would the court say? The court say that term is so vague, so obscure, can mean so many different things to so many different people that no jury could agree on it. Same with threatening. Barnes practices law in a threatening manner. What does that mean? It can mean 100 different things to 100 different people. I get it has a nefarious incarnation to it, and individuals may have a specific understanding of what it means, but they're not going to agree with one another on what it means. And that's what void for vagueness is. It's if two cops could have different interpretations of what angry means, then the law is so vague that I, as a individual, am not put on fair notice as to what it is that's criminal and what's not criminal. My version of angry might not be everybody else's version of angry, and so on and so forth. So I think that's the Fifth Amendment. The Fifth Amendment due process clause applied to the states with the 14th Amendment, which has its own due process clause as well, just makes it unconstitutional to try to criminalize behavior unless you're put on fair notice with such specificity of definition that cops won't have different interpretations on what it means.
And it's an interesting analogy, actually, because basically you're saying if it's a matter of opinion, it doesn't qualify as defamation under defamation law. And if the law is a matter of opinion as to when someone broke it, then then everyone has a different opinion. You'll never have fair application or consistent application of a law which should apply matters of fact.
Exactly, especially when the what defines an non-actionable opinion in the libel law is something that is sufficiently vague that a jury could not decide it as a matter of fact. And so that is classically, like, for example, if someone says James Comey committed perjury, well, that's something juries determine every day. There's certain elements, there's certain facts, there's a definition with clarity to it. He made a false misstatement of fact under oath. Well, but that's not present here. Angry or threatening is just vague. It's just obscure. And my view is if it doesn't fit, if a jury could not determine it in a defamation case, how could a jury or a police officer or an ordinary citizen determine it in a criminal case where their liberty's at risk? So that's part one of why I think it's unconstitutional. The second reason is I think it violates the Second Amendment under the Heller decision. So the Heller court, I think, correctly determined that the Second Amendment was a right of self-defense. That was their language. It was not a right to bear arms. It was a right of self-defense, and a particular method of that self-defense, a right to self-defense by the means of armed self-defense. And here, this law, it seems to me, it says if you exhibit a gun in a particular manner they don't like, they can put you in prison for 4 years. That's what the statute is, a 4-year felony. And they would both be disbarred under Missouri law. So those are saying, this is no big deal. The prosecutor said, I'll probably agree to diversion. That's a bunch of nonsense. These individual lawyers face disbarment if they're convicted or they agree to the diversion agreement. So this is clearly meant to weaponize the criminal law to prevent people from defending themselves against rioting, looting groups of people that have been doing it now for weeks and really have been doing so for years, particularly Ferguson, which is not far away from St. Louis. They've been doing it for about 5 years. So the different versions or variations of it. If you've been in St. Louis the last half decade, you saw the real risk and threat of rioting, looting groups over the last 5 years that could come to any neighborhood at any time and ransack it, or attack individuals, attack property. They're doing so nightly in the city of Portland, right as we speak. Well, did so again last night in Seattle. So, by the way, all of that will be relevant evidence for them in their case. But before we get to the facts of the case, in terms of the law aspect, the Second Amendment says you have a right of armed self-defense. This statute says if you exhibit your gun in a threatening manner, which can be, in fact, for self-defense, then you can go to prison. The fact that there's a separate set of statutes that allow justification to potentially be a defense, to me, doesn't salvage the statute from its unconstitutional provision, because as written, that statute does not incorporate the justification provisions. And as written, that statute, to me, clearly criminally punishes people for exercising armed self-defense, and that I think is true on its face. But even if you didn't apply it on its face, as applied here, and there's two kind of constitutional statutes to any constitutional challenge to any kind of statute. One is on its face, it's unconstitutional. The other is as applied to these set of facts or these individuals, it's unconstitutional. I would bring not only a facial challenge on Second and Fifth Amendment grounds applied to the 14th Amendment, but also an as applied challenge on Second and Fifth Amendment grounds. Because I think this is attempts to do an end run around the right of armed self-defense. The right of armed self-defense is the right to exhibit my weapon in a threatening manner if I'm doing so for the purposes of self-defense.
Well, that's exactly it. It effectively, if not outright, creates a presumption of guilt. Whereas if you are brandishing a firearm for the purposes of self-defense, necessarily you're going to look or be angry when you're doing it. And in which case it creates the presumption of guilt, and you have to then counter that presumption by showing that it was a bona fide self-defense. And even in that case, it could be both, in which case it could be bona fide self-defense, but nonetheless a crime under the law as drafted, in which case, I mean, this is getting to the fundamentals. If this law stands, and if they're found guilty, then what is there left of the Second Amendment?
Exactly. Precisely. So I think at a minimum, it puts pressure on the courts to say that the justification statutes have to be incorporated into these statutes in order to save the statute from unconstitutionality under the Second Amendment. And then you have clear self-defense rights. And that those self-defense rights in Missouri, where they have the castle doctrine, where you don't have to retreat, all of that, is that if you reasonably believe, and I think there's a problem with the word reasonable belief, it needs to be subjective, not objective, because if it's objective, it raises problems under the willfulness provision of the also due process clause, the criminal intent level. But putting that aside for the moment, if you reasonably believe someone is threatening to trespass upon your property, you can not only use your gun, you can physically restrain them, physically assault them, and even use lethal force against them in certain contexts in Missouri. So the law is real broad about being able to protect your property. And so assuming that justification statute is properly applied as a defense, the way it works is the defendant has to raise it, and then there's a burden of production, if you will, on the criminal defendant to say, I'm raising this defense. Then the burden shifts back to the prosecution, and this is also for due process purposes is why they do this. It says that the government then has to prove beyond a reasonable doubt that you did not have a reasonable belief that anyone was trespassing on your property. And that's where I don't see how she could possibly get there, the prosecutor in this case. She cannot, I don't see how she can show that these two defendants did not have a belief that these individuals had trespassed on their property when everything around is private property that only they have a right to. That was not a public street those people were on. They had broken through a gate. That was a private street. I get they wanted to go to the mayor's house. The mayor chose to live in a gated community. Once that's the case, the reason why we have gated communities, those people live there, is they want to make everything within it private. That there isn't a public park that's a private park just for the residents, not a public pool, private pool just for the residents, community hall or rec hall just for the residents, and the streets in particular just for the residents. A lot of gated communities arose because people wanted their kids to be able to play out on the street without risk of kidnapping from, I think it was exaggerated, but the 1990s had all these kidnapping stories and also child care abuse stories, a lot of which turned to be false. But the But that's why they did it. They did it legally so that no one can even be on the sidewalk or the street without permission of some member of the community. Since these people had just broken through the gate, they clearly did not have permission of the community, any member of the neighborhood to be there. So they'd already committed a legal trespass at that point. They're on their property. These people are walking right next to, or in some cases on their property. There's some dispute about that because they've had an ongoing dispute with the gated community to claim they own more property than the gated community claims they own. But they're on record prior to this case happening of saying we believe this also is part of our private property. But at a minimum, these people who were on private property were threatening to trespass onto their homes. They just brandished the gun. That's it. They never even fired the gun. This wasn't like Cinco de Mayo, where Mexican Americans all over the country fire guns up in the air. Apparently now they can all be charged with crimes if this is how the law is going to be applied. That's why this is nuts, this application of the law. Just one illustration of it. I don't see how the prosecutor proves beyond a reasonable doubt that they did not have a reasonable belief that these individuals were threatening or actually had trespassed onto property. The other part that's relevant factually is they get to get in their state of mind. And for their state of mind, in my view, if I was their defense lawyer, I would be introducing into evidence every single example of rioting and looting that's happened in the last 5 years all across the United States. Say that people dressed like this, acting like this. Not only, I mean, they've been doing it aggressively within the last 2 weeks, but also they've been doing it with Ferguson for the last 5 years. That whenever the opportunity presented itself, what might look like a peaceful protest quickly devolved into rioting and looting when the opportunity presented itself with groups dressed like this, behaving like this. And that's why we had a reasonable belief that we needed to defend ourselves. And so I think, that's my short summarized version. I don't know if I'd call that short, but that's my summarized version of the complaint.
Actually, issue. Two things to bring it back. I was saying district attorney. It's a circuit attorney who brought the charge.
Yeah, I prefer district attorney because that's how most people know state prosecutors. So even though the nomenclature in Missouri is that the state prosecutor is known as a circuit attorney, and they're known as different things in different places. Sometimes you have city prosecutor, county prosecutor, etc. I use DA because that's how most ordinary people know them. They know the DA versus AUSA. And so you're correct. The proper terminology is circuit attorney. It's someone who's backed by Soros's groups, got a very strong political agenda about weaponizing the prosecutor. She's been releasing people that have been arrested for looting and rioting right away, hasn't been holding them on bail. So the political discrepancy and selectiveness, and that's the other challenge I would bring. I would put this prosecutor on trial. She brought a very political case a couple of years ago that helped remove a Republican state official, and turned out that the prosecution was based on bogus evidence. I've had other cases. I got a case that's coming up in St. Louis that involves a major bank in St. Louis politically discriminating against a major real estate investor. So there's a history in St. Louis of this happening over the last 5 years. I've had several other cases that touched on St. Louis prosecution. So I'm familiar with political motivated prosecutions, and the corruption of the prosecutorial process in St. Louis has been going on half a decade. Ever since Ferguson, they got very political in St. Louis.
Okay, actually, I'm going to do these super chats so that I can get them off my conscience. Bug Pop, can the federal government withhold funds, pavement markings in a right-of-way that don't regulate, guide, or warn? I'm thinking of Chapter 1A Manual of Uniform Traffic Control Device. Robert, if you know this, more power to you.
Well, yeah, I mean, basically the feds can always withdraw funds for a range of reasons involving compliant issues, and that includes road funds. They cannot they can't force the city or state to do something, but they can always say, if you do it, we're not going to send you money. So that's the difference between the sanctuary city laws that did not get upheld, the ones trying to require local governments to assist with immigration prosecution, that the government can't do. The ones that did get upheld were the ones that said, we're going to withhold funds if you don't do this. So you can use the carrot, but not the stick when it applies to federal-state relationships.
Very interesting. All right, we got Metazone 101. A Kentucky couple has been arrested, placed on house arrest, made to wear ankle monitors after the wife tested positive for coronavirus and refused to sign papers that stated she would self-quarantine because of wording. Lawful.
Probably because that's a true quarantine. There you're quarantining a person that's not because that's healthy, but that has tested as sick. So under our quarantine laws, it's very unlikely that would be denied. I'm not a fan of those provisions, by the way, but under our existing quarantine laws, it would likely be held as lawful.
Right, I missed this one. It was Sad Wings Raging says the process is the punishment, just like Flynn prosecution is bankrupting Ken and Karen with the Missouri couple. I mean, it's an interesting point.
They have a lot of resources, so if they're smart, they are not afraid of litigation. So if they're smart, they'll team up. They'll bring a PR defense. They'll bring a trial defense, and their trial defense will be a mixed bag of people. And if I were them, I would bring a civil rights claim. I would sue the city. I would sue I would sue the state. I would sue the prosecutor and sue the local governing authorities under the law that this is a violation of Second and Fifth Amendment rights. I would escalate the political significance of this case. They are, just by them being politically active and defending themselves in the court of public opinion, they've already got the governor of Missouri to say that he will likely pardon them.
See, this is where the interplay between making public statements during an ongoing matter, social media, Twitter, etc. Like, what's the relationship between this circuit attorney? The district attorney and the governor? Like, do they get along? Are they politically?
Not at all. You have a very liberal, George Soros-oriented circuit attorney who believes in politicizing the prosecutor's office, who's part of Black Lives Matter and social justice and all of that. That's why she lets the rioters and the looters walk free. I mean, this is the African-American police officer, Dorn. He was killed in St. Louis. So the city has been nuts now for a couple of years, really, but really bad for the last several months. So she's way to the left, has used her position to go after conservative Republicans for very questionable prosecutions using unethical manners. She has ethics charges pending against her right now. And while on the other hand, the whole state is very Trumpish Republican. So Senator Josh Hawley is from Missouri, very populist state. The governor is Republican. The attorney general of the state is Republican. I think for example, I think the attorney general is appearing tonight on what's her name, on one of the Fox shows, Shannon Bream. So that gives you an idea. So it's a political war in Missouri where you have this two liberal jurisdictions, one in St. Louis, the other in the state capital of Missouri, where the University of Missouri had a whole Black Lives Matter thing 5 years ago that went kind of crazy. So you have this woke left that's surrounded by old school populist politics. It used to be old school populist Democratic politics in Missouri, but now it's old school populist Trumpish politics in Missouri. So she's doing the Trump side of the equation a lot of favors by bringing this prosecution. But it shows you where they're at. They're just like the lawsuits in Portland, that they are they're in their own tiny echo chamber. So like I was getting attacked a lot by people today on social media because I said I thought this prosecution was a bogus prosecution. And it's because people on the left have really convinced themselves that of their own story. They are really not listening to anybody on the right. So like they think Antifa doesn't really exist in the Portland context. They think that what happened here was some nice, innocent young kids were just trying to do a protest when these crazy white people ran out of their house, pointing guns at them and threatening to shoot them. They really think that's the story. They don't realize the kids were in a place. Well, one, a lot of them weren't kids. Two, they were dressed in a way meant for war, not meant for protest. Number three, it comes in the context of a lot of violent protest and rioting and looting, which they've somehow suppressed from their public knowledge. And these folks had every reason to believe they were at risk. And these folks were in a place they were not legally allowed to be. And it just broken down a gate to get there. The other thing people keep forgetting is about First Amendment. For public protest, you are supposed to get a petition to protest in most cases. So the idea that you can just take over city streets in the name of the First Amendment does not entitle you to take over streets, take over neighborhoods, take over buildings. It never has.
No, and in Canada and in Quebec, I mean, I'm fairly certain you have to apply for it. You have to let people know, the authorities know what your route is. You have to stick to the route. And
local neighborhoods can actually file protest or can file complaints or say, hey, we don't want this to happen here. Local neighbors can do that because they can say, hey, these problems have occurred, so on and so forth. So that's why you have a strict map. There's a specific legal process you have to go through. Now, if the state is unreasonable in denying that can be a First Amendment violation. But otherwise, there's supposed to be a process in place to keep people safe, keep people secure, maintain the other duties and obligations the government has. There is no First Amendment right to just go into people's neighborhoods, take over their neighborhoods, and stalk them. That has never existed.
Okay, now I also want to, in the statement that the CA released, says, okay, well, we press the charges, thoughtful discussion, et cetera, et cetera. We just press charges against protesters who violently
other individuals who assaulted
peaceful protesters. Oh, as
I
if
love using the word peaceful protester. There's been very little peaceful protesting in St. Louis.
But either way, even if it's 100% true, to equate what we know that we saw with the idea of violent assault on peaceful protesters is just like it's to color your opinion. But
yes.
The question is this: they mentioned the diversion program in the release, as if to say we're going to let them off anyhow, no biggie, to lessen the what I think is the absurdity of the charges in the first place. Two things: can the couple say we don't even want, even if you offer us a pretrial diversion like you did Jussie Smollett, by the way, like just to equate the crimes, the alleged crimes to other crimes? Can they say we don't even want this? We want you to press charges, we're going to defend?
Yeah, diversion, I can explain to people. It varies. There's not a lot of diversion in the federal system. There is, except oddly enough, on a random tangent. We'll have our occasional tangents on the podcast. I happen to be watching a podcast called Concrete, but it's spelled with a K, where these kids interview famous criminals. So I was fascinated by it. Watched one. It was interesting. It was about the English Sean, fascinating case. He'll describe how crazy our prison system is and how dangerous it is, bad it is. But he does a lot of Epstein coverage. Fascinating guy. So I went to grab a drink, and you know how YouTube is. They just skip to the next podcast or show. It turned out it was another one, and I sat down, and I was like, well, I'll watch a little bit of this one. And I didn't even deliberately turn it on. And about a minute in, the guy gives a name. And I'm like, hold a second. I represented that guy for a brief period of time. And it turned out that the case, there was federal diversion. I'd never even heard of federal diversion. Somehow my very brief short-time client had got it on a prior case. And it turned out he was accused of being involved in a Ponzi scheme. And it turned out not him, but he was in the middle of two other massive criminal schemes, including other Ponzi schemes, including federal government receivers stealing money on the disguise that they were trying to clean up Ponzi schemes, destroying evidence, framing a guy, all this other stuff. So I was like, I had no idea. I was almost in the middle of this massive corruption case that I only didn't stick with because I didn't quite, I moved on from that case. Let's put it that way. I can't go into further detail. But it was one of those random things. But typically, other than that case where somehow that guy got federal diversion, which I didn't even know existed, most diversion only exists at the state level. So most states have, and they've started to increase the implementation of it. And what it is it's basically a deferral agreement. We agree that we won't actually take this case to trial as long as you comply with some almost probation-like conditions. And as long as you comply with those for 2 years, say, then we will dismiss all the charges at the end of this process and you'll have no criminal case against you. So New York has a version of this. Most cities, counties, and states have a version of this. They tend to do it in political cases where they want to make a big deal up front. Look, we brought the charges. Look how terrible the charges are. And then they quietly do a deferral agreement on the backside of the equation. The Epstein agreement was originally intended as a deferral agreement. Then they ended up not doing that because that guy wouldn't have kept his word. But that's what those are. And it's what is highly unusual is for her to talk about it out of the gate. To say that, hey, by the way, I really just brought this prosecution for PR purposes, and I'm just going to give them a deferral agreement, and I hope nobody gets mad at me for bringing this crazy prosecution on the Republican side in the state, given the governor's already said he's going to pardon them out of the blue. I've never seen that happen. So it does not surprise me that they're proposing a deferral package. As a defendant, you almost never want to take that unless you have to, because you're stuck under the government's thumb for 2 years. They can use any pretext to call it to put you back on the trial track. And there's an inference of guilt. This is the biggest problem. There's an inference of guilt, even if there's not a legal finding of guilt. That makes it, and especially when you're a lawyer. And I guarantee you, the people who run the licensing board in Missouri are probably lean to the left. I've dealt with this in multiple contexts and even quote unquote conservative states. The people who run the licensing boards or the enforcement organizations for the state bar or the Supreme Court overwhelmingly lean to the left, in my experience. And so they're going to be political targets right away. I'm sure there's already a complaint pending before the state bar.
Yeah, that's crazy. All right. I don't think I have any more questions on that. I guess the one question is if they challenge the constitutionality of the statute or the law, it would just be the standard judge who would adjudicate on that. They would hold a. I mean, I guess that they would not hold that trial before jury. That would be strictly a legal question the judge would adjudicate on before they move forward.
Exactly. It'd be a motion to dismiss. You could bring it as a civil rights claim. It's tough. Theoretically, you could bring a case in federal court and try to enjoin the state prosecution. Try to have the federal court issue an injunction against the state criminal prosecution on the grounds that it's an unconstitutional prosecution or the prosecution violates constitutional rights. And this goes back to obscenity cases and other cases where they've done this. As a general rule, there's all these exemptions that preclude federal courts from exercising their discretion to issue injunctions in an ongoing state criminal prosecution. Ex parte Younger, whole range of cases that deal with when you can and can't enjoin the government, the state government, when the federal court can and can't enjoin the state government. So it'd be a little bit tricky whether they could, but I think it's probably worth an effort. If I were in their shoes politically, legally, I would parallel the case, especially if it depends on how much I know or trust or have confidence in the state court system, because the criminal court case will be pending in the St. Louis County court system, circuit court system, the state court system, and then you'd have a court of appeals and a Supreme Court in Missouri. The federal court system might be more protective of civil rights in this context in such a politicized case. So you might try to go that route. And then you'd have the federal court of appeals that governs Missouri, and then you'd go up to the U.S. Supreme Court as needed if they would take the case. So all of those courts could be involved in deciding the process depending on how and whether they choose to raise this defense.
All right, I'm going to say, Mark Montillo, I paid $20 for a super chat and you ignored it. Did you just steal money from me? I don't ignore any super chats, but I cannot get to all of them. And like Uncivil Law, another YouTube lawyer says, it is not necessarily a right for discussion. And I specified at the beginning, I try to get to all of them. Ask the question again and I'll make sure to get to it here. But just so everybody knows, there's a lot of them, and I reserve the right to miss them because it's a wonderful problem to have for me. But the super chats are support for Barnes and I so we can continue doing this. But I do my best. I am by no means perfect. So I just forgot what your name was. Mark Montillo. But ask it again because I don't like people having hard feelings. And when I see it, I'm going to get to it. Okay, well, I don't see it yet. But I'm going to wait for it because I'm going to forget otherwise. Okay, so that's amazing. I just wonder when the level is that we're going to get to actual malicious prosecution claims or lawsuits, because
it's so hard to bring them. You have to show they had no basis whatsoever to bring it, and the courts never want to make that determination. So even Flynn would have a hard time bringing a malicious prosecution case against the U.S. government. That's how hard those cases are.
Well, you know what? But I almost, I hope nobody chews me out for this. I almost would understand that more for Flynn because he in fact pleaded guilty in the whole situation there. I could understand that. These people, I don't know how many people look at this and think that there was anything that they saw in there, knowing the context, that could justify bringing these charges. And to me, it just feels purely political. It almost feels like someone made the comment, like almost as though this district attorney was being goaded into pressing the charges by a tweet from the governor, and then she took the bait. But it really I'm looking at this from Canada. It just looks political. Nothing more to it. Not factual, not legal, just purely political.
Well, especially the same people demanding we empty the prisons. The same people demanding we not arrest people for disorderly conduct, not arrest people for a lot of the physical property damage that's taking place. The same people in Oregon that are suing to prevent the feds from enforcing federal law are turning around and saying, let's make sure the dog walker in Central Park could go to Rikers for a year. And let's make sure an elderly couple defending their house can go to prison for 4 years in Missouri for simply coming out with guns to tell people not to raid their house. How does that make any sense other than pure politics? It's okay if I decide to destroy a storefront. According to the same St. Louis prosecutor, she's letting those people walk. But if I go out and just show people I have a gun, please don't raid my house after you've already illegally trespassed onto my neighborhood, then I'm supposed to go to jail for 4 years? For a prison system, they're saying they want to empty the prisons and don't want anyone in jail, really? So they're showing how political they are. They're showing they don't care about avoiding the criminal justice process, de-incarcerating it, that the incarceration system is a cancer on our society. You can't say that and then turn around and say you want a couple of old people locked up or a Central Park dog walker locked up. That they're exposing themselves to the world as the frauds, the phonies, the fakes, the hypocrites that they are. They want to weaponize the prosecutorial process for their political advantage. And to give an example of what I mean by refusing to allow politics to govern how you interpret the Constitution, probably a fair transition into the Ghislaine Maxwell bail decision.
Now let's
and so I'll say something that a lot of people won't like. I know because they've already made it clear to me, but the Eighth Amendment is there for a reason. We cannot use bail to punish people. And I understand why people want Ghislaine Maxwell punished. There's a lot of evidence out there that would justify a severe punishment, that would justify excluding her from civil society. But that isn't what the bail is about. Bail is solely there constitutionally. Eighth Amendment to the United States Constitution. You cannot require an excessive bail. And what's the definition of bail under the Eighth Amendment? The definition of bail is to secure your appearance at trial, period. It is not for punishment. It cannot even be used for punishment. Punishment cannot even be thought of in that context. So ignore the name Ghislaine Maxwell and just put the facts on there and say, do those facts show reasons to imprison this person, incarcerating this person, pending trial as the only possible means to secure their appearance at trial? And when you looked at the evidence that developed at the bail hearing, and here's how bail is supposed to work. There's a statute. They passed the Bail Reform Act, 1986 or 1984. The U.S. Supreme Court affirmed it in 1986 in a very controversial 5-4 decision, in which they added, you can also now deny someone bail based on clear and convincing evidence that they are a imminent danger to the community. I've never agreed. That's not what the Eighth Amendment says. They just ignored it, unfortunately. A bogus case because they had someone, the criminal defendant who was arguing against the bail laws, he had already taken a deal, so he wasn't actually arguing against it before the U.S. Supreme Court. So you just had the government arguing there. It's totally bogus. But the still narrow 5-4 decision. But under the statute, what was supposed to happen originally was the prosecution has to present actual evidence at the bail hearing. You as a defendant, because of the Fourth and Fifth and Sixth Amendment rights that are implicated, you were supposed to be able to allow to do a proffer. Just say, here's what I could prove if we had a hearing, but not have to actually produce the evidence of it in order to protect your client's right against self-incrimination. And it was otherwise your client's put in a position where they have to choose to either potentially waive their right against self-incrimination or their right to bail. That's putting two constitutional rights. You're conditioning one constitutional right on the other, and that's called unconstitutional conditions, the unconstitutional conditions doctrine. So in order to protect against that, you as a defendant were supposed to be able to proffer evidence. Unfortunately, that's not what's happened. These days, what happens, they allow the prosecutors to proffer evidence, often require the defendants to effectively produce evidence, and often presume, and the legal standard is supposed to be, does the court find, based on evidence, by a preponderance of that evidence, that there is simply no way possible to make sure this person shows up for trial other than custodial incarceration. And here the alternatives include massive cash bail, included a home detention, included electronic monitoring. And if I had been Maxwell's counsel, I would have argued for federal protection, federal protective services, because there the marshals have a very sophisticated system of protecting witnesses. She could pay for it. You could order her to pay for it, all the cost related to it, which will be cheaper than incarcerating her anyway, where the state has to pay that anyhow. And it would prevent the risk of death, which just happened to Epstein. So I would say, and here's the evidence that she had. Here she was not a citizen of the United States, citizen of a bunch of other countries around the world, at least the UK, probably others. A lot of access to resources, known about the criminal case for more than a year, and yet she stayed in the United States. And they're like, well, she was kind of hiding out in New Hampshire. Not really. She simply didn't identify her name on the property deed because she'd had a whole bunch of death threats. So she didn't hide out from the feds. The feds didn't have any problem picking her up. They knew she was legally represented. She knew that they could be coming in any moment. And yet she never fled the United States. So if she wasn't going to flee now, why is she suddenly going to flee after she's arrested? That's number one. Number two, how is she going to flee? If you're on home detention and electronic monitoring, or if you're in federal protective services, there's no history of those people escaping. So how are they going to escape custody? And even if they escape imminent custody, how are they going to get out of the country to some place that doesn't extradite? Because for these charges, almost every country in the world extradites. So the probability that she was going to escape And then how was she going to get access to resources? Did she already have money hidden in a Namibia bank account and she was going to hang out in Namibia on the beach or something? There was no, the government says all the time, oh, this person will flee. And that's not the legal standard. The legal standard is, can they successfully avoid presence at trial? Almost nobody can in the modern world, not for these kind of charges. The U.S. government gets people back from countries where there is no extradition treaty. They do it all the time. They've done it in cases I've had. So so I thought constitutionally, Ghislaine Maxwell deserved bail. People hate her justifiably based on what public information is there about her, and they allowed bail to be used as punishment because they don't like her. That violates the Constitution. That's politically changing our definition of the Eighth Amendment because we don't like the defendant. And that's what the left is doing and is wrong.
Well, the ultimate irony is that everybody, not everybody, but a lot of the people who are angry that she, sorry, hold on one second. The people who say that she did not deserve bail because of what she's accused of, are also the same ones who generally, and I suspect she might very well meet Epstein's fate in jail. And the irony is that however bad she is, or may be until, once proven guilty, she might actually be safer not in jail than in jail. And so
absolutely.
The idea that everyone, the more you hate her, the more you presumably want her to stand trial, and the more presumably, therefore, you would not want her in prisons in New York where security cameras go blank. And the flight risk, I can understand people are going to say she's a flight risk. We're sort of living in times where flight risk is not necessarily the same risk as it used to be, although she probably has means to private jets and private yachts and whatever. But
even there, because I've done this in so many cases. One is you can't get on a private plane. People think you can get on a private plane without them knowing about it. You can't, because you have to get permission to leave your airport at least an hour before. Everybody that's listed, everybody has to be listed on there. And like in this context, let's say if you're in Federal Protective Services, I don't know how that happens, because they're the only ones who know where you're at. That you're not allowed any communication. They control communication through your counsel, who talks to the Marshal Services, doesn't talk to you directly. They don't allow direct talks to occur. So you're completely in isolation. She was already I bet her lawyer told her that if she behaved like she was already in Federal Protective Services, she would get bail. Because honestly, it was a mistake to be in the United States. She could have negotiated her return and got it released if she had not been in the U.S. But that ship has sailed. What the lesson of this case is not to be here, because the government's always going to try to detain you if they can. It doesn't matter what the case is. They detain all kinds of people on the lamest grounds. But take, for example, the idea, I have a private plane. Doesn't matter. You have to get an hour clearance. And if you try to take off without having that clearance, they shoot you down. In the post 9/11 era, there's nobody hopping on a private plane without full clearance in advance. So your only risk is whether a pilot is willing to risk his license and prison for aiding and abetting an escape by not putting your name on that itinerary. Even then, getting out of the country is tricky. Let's say you get out of the country. Then you have the next problem. Which country are you going to get into? Your passports have likely been suspended or revoked. So you're going to have difficulty clearing any border. So unless you want to hang out with the Mexican drug cartels, there's not a lot of places you can go once you've been indicted. Let's talk about boats. Same problem with boats. You have to get clearance an hour in advance before you take off. They monitor those excessively. That's where people think, they think it's a Miami Vice era. Not anymore. Post 9/11, there's almost no way to get in and out of this country other than physically over the border. That's the only way to do it. And for that, you need Mexican drug cartel friends. Now, maybe you can sneak into Canada, but Canada will extradite you for these kind of offenses. Almost every country in the world will now extradite you for these kind of offenses. The few countries that don't have extradition treaties with the U.S., I'll give people a little word to the wise. You generally don't want to be in those countries. Those are not countries that are joyrides. There's a reason why those countries don't have extradition treaties with the U.S. And those same countries will deport you at a moment's notice. So they get around the extradition treaties all the time. So and Maxwell, someone that's publicly hated for a crime that's publicly reviled, if she'd come to me and said, "What's the possibility I could avoid trial?" I would say less than 10%. I said, unless you want to live in a cave and want to forfeit everything you know, and forfeit every relationship you know, and forfeit everything you've ever known about your life, you're likely, except for the risk to death for her, you're generally better off in it. Your material well-being, you would live better in a federal prison than you would in most places trying to escape a federal prison for the kind of charges she faced at the profile she faced. So as a practical matter, and I know of no one who has escaped that wasn't a foreign national part of arms running or the drug trade. Those guys can escape.
Well,
that's their world.
What is to stop Maxwell from doing like Carlos Ghosn?
Honestly, I don't know about Carlos Ghosn, so I'd have to look it up. I can tell you that the only thing that, if you're willing, now Mark Rich escaped, but Mark Rich never fled. Mark Rich just didn't come back for the indictment. Mark Rich was protected by multiple forms of citizenship. Mark Rich was protected by the Mossad, who he was deeply embedded in business with. Now, there was rumors that Ghislaine Maxwell had those connections, but there's another reason why Ghislaine Maxwell wouldn't trust that. Remember, her father was likely killed by the Mossad. So the idea that she's going to go running to the protection of some foreign government when what happened to her dad is unlikely. You can, by her course of behavior, she was clearly believing that she was more at risk from people out there other than the U.S. government. She did not think of the U.S. government as her biggest threat. She thought of other people as her biggest threat. Now that she's in MDC, by golly, they better make sure nothing happens to her, or the whole system will become a joke. So we'll see how that goes. But I think they violated her 8th Amendment rights because she's hated. That when we always violate our constitutional rights, we do so when the public hates the person whose rights are being violated.
A lot of people were asking why there was no perp walk, mug shot, things like this. Do you have any answers?
It's all virtual. They didn't do a physical bail hearing because I considered going to it. She appeared by videotape from the jail. Everybody appeared by videotape. Most things in New York right now are by videotape.
Okay, interesting. Yeah, no, it was, and then the flip argument is why couldn't they have just set bail at $50 million?
Yeah, but that would be an excessive bail. So it's whatever amount of bail she could afford to post. And in the federal system, it's not like the state system. State system, you can get a bail agency to post. You just give 10% to the bail company. The bail company posts it. That's not allowed in the federal system. They have to actually post real bail. So they have to so if they say 50 million in bail, they mean they need 50 million in assets, and there's almost no bail company that will do that. So the few bail companies that do it require you to give them property worth at least 50 million. So she was not in the same category as Epstein. She probably had 5 million to 10 million, maybe most. Now, she did not disclose her finances, and that was part of the argument used against her. But there again, there's a lot of reasons not to disclose that information given the position she's in. And my whole argument was simple. If she was going to flee, she already would have. Number one. And number two, we know she's not safe in custody. So put her in Federal Protective Services, she might be safe, but no way she's going to be safe in a New York facility because Epstein just got killed, just got whacked. We all know it. I would have made the court system feel humiliated and embarrassed by all that. Her lawyers did not even raise it. So that's because they're conventional lawyers who probably went, hey, look, we were here the whole time. My client was here the whole time. Didn't have to be here the whole time. Surely they'll just apply the law. No, in political cases, they don't apply the law. They bend the law to fit whatever politics they want, or they just break the law to fit what politics they want. Her lawyers did not serve her well. So now she's at high risk. And I mean, the biggest thing with her is not whether or not she gets punished. That's almost a guarantee in my view, given the facts that have been developed against her over time. It's though she does have some legal defenses about statute of limitations and particularly not so much, well, a little bit statute of limitations, mostly about whether or not she was protected under the Florida deal and whether as a third party beneficiary. The other thing they're doing is they're using the Maxwell case to say that even when they cut a deal meant to benefit a third party, they can violate that anytime they want because the third party wasn't a signatory to the deal. They're trying to unravel every prosecutorial deal done in the last 30 years. A lot of deals get done by third parties being protected who are not listed in the plea deal, except indirectly or by categorical reference. And so it's the government always uses cases of hated defendants to break the law or change the law in a bad way. And they're doing so in the Maxwell case.
All right, interesting. Now, Jason McConnell says, I agree fully with your points, but I'd throw up Carlos Ghosn as a counterpoint on the private jet issue. And I looked at another super chat and brought it up, which said that Carlos Ghosn mailed himself in a crate from Japan to Lebanon. So
yes, if you're real creative, you can get out. But normally what you have to have, so like there, he's ultimately going to Lebanon. It's people that are tied to gun runners, tied to rogue regimes. So if you're willing to live in Cuba, you're probably going to be safe. If you're willing to live, back in the day in Angola, like Eldridge Cleaver, you're probably going to be safe. But you need political protection. And what you'll find is most people, they go nuts in those places. They can't mentally handle it. Most of them regret it. Most of them come back in 5 or 6 years. They all go stir crazy because the thing that gave them that lifestyle is all gone. That's why the only people who successfully flee are people whose lifestyle was already that kind of lifestyle. Terrorists, major drug dealers, gun runners, those kind of arms dealers, those kind of people, or people like Mark Rich, who was a little bit of all the above, who was connected to the Mossad, had tight ties to this. Here's what people don't know about Mark Rich. The U.S. government chose not to ever pick him up because he was doing deals with the State Department on a regular basis for 20 years. That was the hidden fact about Mark Rich. So they let Giuliani prosecute him, indict him, but they had no interest in bringing him back. The Department of Justice tried to keep getting him, but the State Department interfered with that because Rich was a key asset to the U.S. State Department. So that's how these things happen behind the scenes. But behind the scenes, the feds knew Maxwell wasn't going anywhere. They don't care because either they want to prove to everybody that Epstein was a one-off, or maybe these are not the most straightforward prosecutors who don't mind if she dies. Because the biggest thing with Maxwell is not whether she gets punished at this point. It is solely the information that's in her head that is the last one left who has that information, and whether she gets to tell it to the world or not. So we're going to find out whether or not that occurs. My guess is that it never occurs. Something's going to happen between now and then.
Well, my guess is I figure even if she has the information in her head, I think there's going to need to be some material evidence to support it, because a lot of people might write it off as just what someone says. There's got to be pictures or videos, or she has to have access to a stash of evidence, which...
Well, she gave. I guarantee you she has evidence that would put Prince Andrew into prison in the United States. But we'll see if that doesn't develop in that direction. Then this was a cover-up prosecution, not a exposure prosecution. And I'm deeply skeptical of the Southern District of New York. Now, it is noteworthy that 1 week after Berman was removed, this prosecution came about, because this by the way, what she's being prosecuted for, the FBI had evidence of in 1995. That's what she's being prosecuted for. 2 criminal investigative reports that went to the FBI in New York in 1995. That's what they're now finally indicting her on. So, and they said they're contrary to some rumors, they said there's not going to be a superseding indictment. So the main thing they're prosecuting now, what is some people ask about statute of limitations. For certain forms of sex trafficking, there is no statute of limitations other than the person's life. So, by the way, which is totally wacko. So, if you're going to sexually traffic someone, the U.S. government's advice is to kill them, because then we have to find out within a year or you get to walk free. I've never understood that provision. My view is treat it like murder, no statute of limitations, period. Whatever evidentiary problems you have, and you deal with it accordingly. The idea that it's within 1 year of their life, so you give an incentive to sex traffickers to kill the people they've trafficked, has never made any sense to me.
Amazing. Okay, it's very interesting, and these are my thoughts also in terms of the bail. I said it didn't make sense. There were alternatives that were probably more secure, more reasonable, more proportionate, but above all else, that would protect her more than being in the very same system that did not manage to protect the other name who cannot be spoken, that couldn't protect Epstein. And I think we all pretty much, most people suspect what happened to Epstein is not what is being reflected in the mainstream narrative. But
two great truths in life: Epstein didn't kill himself, and Sally Yates is corrupt.
All right, now I'm going to get to the super chats that I missed because I took pictures of them as they went by. Mark Montijo's super chat was: if I stand in front of my house with a trained guard dog, which will defend me if approached, then is it the same as a defense firearm? I just want to deter people from attacking me at my home. What are my rights? Well, without getting,
it would be whatever the dog custody laws are. So from a home insurance liability civil perspective, if your dog causes injury to someone, that you can be held responsible for it. I don't know what the criminal laws are regarding that, to be honest with you. That's a good, interesting question. I'm curious because this law is specific to the brandishing and exhibiting of guns. I don't know if you can be held criminally responsible for the behavior of a guard dog. That's probably an interesting question. You probably can.
No, that's the thing, and I'm fairly certain, because it was one of the more traumatizing videos I saw when I was a kid, was this mentally ill woman who sicked her pit bull on the people who come to get dogs, and I believe she was charged with assault with a deadly weapon. In fact, I'm fairly certain she was, because I remember being traumatized by the whole video and everything. But yeah, no, it's an interesting question. It's but one thing is for certain: you have Second Amendment rights in the States, or you don't, and especially in this context, having this charge pressed against you in that context undermines that right.
No doubt.
Anthony Leira, Loera, Laura, $50 super chat. So thank you very much. Mask isn't defined. This will bring us into our next subject. Mask is not defined. So can I wear a paintball mask, which is just a wire mesh strainer over your mouth and nose in Colorado, Florida, and Plains?
Yeah, it's to the degree that anybody has defined it, they've simply said a covering of your nose and mouth. They've said nothing else. So it appears that anything would work. So you could, any kind of mask would appear to be okay or appropriate. Now, we'll see how they respond to some of the more creative masks that people might start wearing. But at least on paper, there's no limitation. Now, I'm going to be bringing suit this week against Trader Joe's for the case that went viral on video of the lady who they only taped. This is another problem that it's also occurring. Involuntary taping of people, selective editing or selective taping of those people, then publicly humiliating and shaming those people based on misleading edits of a involuntarily made video of that person. And so what happened is at the very end, they taped her being angry and leaving the store, and everybody attacked her and mocked her. A bunch of media hit pieces came out. Here's the whole story. She has a severe medical condition, as the suit will detail, that makes masks dangerous for her to wear. She had contacted Trader Joe's in advance to make sure that she could come there. They said, and without a mask, explained her, they said, absolutely. They understood that that's required under the law. She goes there, and a bunch of the mob starts to attack her. And this is an underreported phenomenon. I'm getting tons of reports of this from all across the country. People, you go to a pub, you get attacked by other people. This man starts being physically threatening towards her, physically approaching her, calling her the C word, just cussing at her. Other people start cussing at her, start gathering around her with a lynching mindset mentality, attacking her. All these people, but by the way, the rule in almost all places is that you, even inside a public place, you only have to wear the mask if you're within 6 feet of someone else. You can actually take it down and off if you're not within 6 feet of someone else in most places. And that's because the very limited scientific theoretical evidence, and I emphasize theoretical, behind supporting the mask is that maybe if you're within 6 feet, droplets may spread, because maybe COVID spreads by droplets. They don't know. So if you're not within, and these people are breaking the 6 feet barrier, which is ironic, in order to scream at someone not wearing a mask. So she's getting threatened. Then Trader Joe's employees finally show up, and rather than support her and explain to people, no, that's her right. She has a health condition. Quit discriminating against her. Quit saying these things to our customer, or we're going to kick you out. They join in and support it. And so when she's walking out, very upset and traumatized by what happened, she went through this whole process just to make sure she could shop at Trader Joe's. She turns around and yells at him and then leaves. They only release the video recording of her yelling at them and leaving, not the rest of it. So it's a selectively edited, misleading video. It gets published to the world. TMZ and everybody else decides to run with this misleading story, fails to fully investigate the facts. I'm looking into whether or not we can sue some of them for invasion of privacy, because it's really a false light. They're casting people in a false light. I mean, this all goes back to my Covington case. It's this taping of people involuntarily just because they happen to be in a public setting, then selectively editing it for public mob mentality lynching, reputational lynching campaigns is a bad cultural phenomenon. It's not a healthy one at all.
And just so people, I can maybe hear people saying, well, selective editing sounds like, you're distorting it. Selective editing need be nothing more than starting at the right point or just cutting it at the right.
Exactly. And it's what Project Veritas is accused of all the time, and most of the time they're not correctly being accused of it. They actually include the relevant, pertinent context. The key is pertinent context. So for example, in the rules of evidence in the United States, we have a federal rule called Rule 106, which is called the rule of completeness, which it does not allow for evidence to be presented unless some other piece of evidence has to be presented with it to contextualize it. So to give you an example, let's say I write a letter to you, you write a letter back to me, and I only want to introduce your letter back to me. By the rules of evidence, I get to introduce my letter to you first. And the reason for that is to contextualize what someone's responding to. So in this context, all the video should either be presented or no video should be presented if you only have a splinter of what happened. If you just have someone's reaction, you don't know what they're reacting to. This is what happened in the Amy Cooper case in Central Park in New York. They only had a video of her reaction, not what she was reacting to, which was his threatening language about, I'm going to do what I want and you're not going to like it. Without all of that context, Covington, same dynamic. They only had the tape of their reaction, did not have the tape of the Native American man walking up to them, did not have the tape of them being harassed by the Black Hebrew Israelites, did not have the context of them doing chants and other kinds that this Native American man joined into. So without context, every single one of us, if you took the 30 worst seconds of our life and responding to something, could look terrible. And this is not, and our rules of evidence understand that. They understand that's not truth. And so what truth requires is completeness, and that's what's not being presented, and especially when people are being involuntarily taped. If you're joining a public protest, okay, I understand then if I get involuntarily taped, different dynamic. But like Covington, they weren't part of the protest. They were together after the protest was over, waiting to get on a bus. Same with Central Park, Karen. Same with this case.
These are people, they're just out in public. They're out in public, and then everybody thinks it's fair game for whatever you want, but it's not the case. No. Robert Rogers says, what about the Julian Westenberg and her husband, the woman that pulled the gun? The full video shows that Julian was the one being attacked. There's no question. And incidentally, someone asked the same question here about what just happened in Montreal, where this guy was at a Tim Hortons. And I know you saw that because I tweeted it before they deleted it from Facebook. And you watched the video. I think you have enough idea about the context, but you don't know certain things like this guy. First of all, someone made a joke that the plot twist was that she had COVID. That's why she couldn't wear the mask. The laws specifically address that medical condition as being not a legitimate reason for not wearing the mask. So jokes aside, the law actually provides for that in most places.
If you've tested positive, a mask can be required.
No, so that's it. It said, if you have a medical condition, that is not the COVID. Yes, but this, this video that went viral and everybody was like, oh, idiot, all you have to do is follow the law. Oh, he resisted a direct orders from an officer. First things, you have a guy, what he was saying was, I don't have to wear a mask. And you don't know in his mind if he's saying, I don't have to wear a mask because I have a medical condition, I have asthma, or maybe he thinks I don't have to wear it because in the law, it says you don't have to wear it if you are eating or drinking in an area designed for eating and drinking. And so,
or if you're about to eat or drink, because I mastered all of these exemptions in my recent travels. So I can figure out, okay, if I'm carrying a drink, I can slip it down. And if anybody says anything, I'm drinking, I'm about to drink. I have snacks with me. I have everything ready in case I get attacked by the mask mob.
Robert, no joke. My wife literally did the groceries today, and somebody walked into the grocery store. They like, put a mask on. It's like, I'm drinking my coffee, and then he drinks and just walks in. I mean, exactly. so you get these short clips. You have no idea what the context is. You have no idea what people's understandings are. But above and beyond all else, you have these ambiguous laws that are, generally speaking, they're poorly drafted because they're drafted in haste. That's just the necessary rule of these emergency measures. They're drafted in haste.
And most of these have not been passed by our tricameral process in the United States. They haven't met legislative investigation. They haven't been passed by the legislature. They haven't been passed by public referendum. They're just executive branch people issuing edicts like they're royal dukes from 500 years ago. We have reverted back to colonial rule and how we're being governed, and often worse than even the colonies did.
It's crazy because I was reading our regulation in Quebec to make sense of what's going on, and the preamble is, whereas an emergency measure was declared on March 15th for a period of 7 days, whereas it was renewed on March 14th, whereas it was renewed. I mean, you have a paragraph of these emergency measures that are being renewed for 3, 4, 5 months now, and they just keep issuing new emergency decrees. I mean, and whatever. It's an imperfect situation, so it's going to be easy to pick on the imperfect, response. But
it's fun to be the king. To reference Mel Brooks' History of the World Part 1. Great movie if people get a chance to see it. It's good to be the king. I think that's the exact phraseology. Well, and that's what all these governors and mayors, they're like, oh, this is great. Yesterday I could tell them you can't wear a mask. Today I'll be like, yeah, you have to wear a mask. This is a degree of insanity that feels like a bad parody, like some crazy Monty Python on LSD skit, but it's reality.
No, and Robert, I had one person say to me, not even one person, a lot of people saying defying a lawful order by an officer. It's like, yeah, it's only a lawful order because they literally last week just passed some emergency measure that is so ambiguously drafted that says you have to wear a face mask unless X, Y, and Z. So just do what the officer says. It's a lawful order only because you just made a ridiculously drafted law a week ago, which incidentally in Montreal doesn't even become a mandatory fine for the violator until August 1st. And what happens? It leads to a guy getting pepper sprayed in the face by the cop at point blank range because he's not wearing a face mask for God knows whatever the reason. And if it was because of a medical condition and he's too embarrassed to state it publicly, officers just pepper sprayed a guy in the face who couldn't wear a mask for a breathing. It's crazy.
You know, if he'd been black, that would have been a whole different political takeaway.
I tend not to play that game because you can always argue that, like, you know, change the identities. I'll just go with the absurdity of the existing situation. It is.
Well, yeah, I was going to create a weapon, a woke taser, so that it only goes 6 feet. So if as long as you're social distancing, I can't reach you, and it doesn't apply if you're black or brown, and it doesn't apply if you have a mask. But for everyone else, you could just go around tasing people. We could create like a little Cartman form of social police for these mask nuts to enforce on a regular and routine basis.
And incidentally, in our law as drafted, which I think has to be the next vlog, it applies to closed public areas or semi-roofed public areas, which I don't know what it means when reading it. But the bottom line is everyone should wear a mask.
Was the guy at the Tim Hortons, was he a French Canadian?
He was French Canadian.
That's fascinating because I know when I was up there, like in the States, we mostly think of French as kind of snobbish. But when I was in Quebec, the French are more like the blue collar. They're more like the working class composed. So they're much more like Southwest Louisiana, which is more working. It's not snobbish culture at all. No, they're more your blue collar populist types.
Well, no, and not to say something that might be offensive to people who don't know the context, but the French from France view us from Quebec the same way the Brits view, you know, the southern states. They view the language the same way. And the funny thing is, like, I'm an Anglophone, but I speak French. I lived in France for a year, and I was like, you know, the guy coming from the south going to the fancy French and speaking with my Quebec French. There's the same hierarchy, sort of snobbery between France and Quebec and England and the US. So
but I like the French Canadian Quebecers, whereas a lot of the French people, they're an acquired taste. But the French Quebecer, they were cool. They they're boat people in the summer. You know, they're much more blue collar, working class, everyday kind of people.
We're fishermen. We the country types. But so this guy's he's in a Tim Hortons. He's like, I'm not worried. I'm ordering.
Those people don't know, Tim Hortons is like the Shoney's or Big Boys or Perkins of the United States.
Tim Hortons is sort of like, it's a little better than Dunkin' Donuts, but
yeah, it's just a real popular diner. I didn't know what it was until I was driving around Canada a couple of years ago.
They're everywhere.
They're everywhere, absolutely everywhere. But actually, pretty good. They're not quite up to Big Boy standards from the South. But pretty, but yeah, close to like a Perkins. I used to work in a Perkins as a kid.
The coffee has gone somewhat downhill recently, but they have a darker blend, which is still somewhat good. The one argument is from the Tim Hortons is that apparently some people are saying they've removed their seats, they've removed their tables, so nobody's supposed to eat or drink indoors, so no excuse not.
That sucks.
I don't know that it's true because there's one up the street. I don't think that's what I saw. But either way, this is the world where people are starting to understand more laws, less justice. You make a silly law, and then people don't follow this, or you make a poorly drafted law. I don't want to call it silly, whatever. It's a poorly drafted law, just objectively. Mm-hmm. I don't care what you think about masks. It leads to situations where people don't understand the exemptions. People might feel uncomfortable stating the exemptions, and it gets to a situation where the police tell the guy to leave, and he's saying, I just want to order my coffee, gets manhandled, and then pepper sprayed in the face, and people are saying, all you have to do is obey the law. Oh, no, it is madness. It's madness, and we're getting there. Someone had asked in a super chat, actually, Florida's talking about drafting face masks in your homes. Let me just see if I took a picture.
Yeah, and there's a state, not sure which one, but there's I know. It's Broward County in Florida.
Yeah,
has already mandated, which, by the way, logically that makes sense. If you believe in the masks, you believe in the quote unquote science of the masks.
The majority of the transmission is in the home. The majority of this is also what I find irritating about the masks. The majority of the transmission, from what I understand, is not in open area public squares where they're only operating at 25% capacity. It was, incidentally, Lother and Prime who says authorities in Broward County have passed a coronavirus emergency order, which includes text suggesting all residents are mandated to wear face masks in their own homes. Legality. The word mandated in this context is starting to bother me, because like if someone mandated them to tell me what to do in my home. But I said this in the discussion to somebody, like, it's not a slippery slope, it's a free fall. And if the mask mandate is justified based on risk, this is the next step, because everybody knows the majority of the transmissions are coming from the houses.
Exactly. And sooner or later, the police can just raid your house to see if you're wearing your mask. How's that going to work? By the same people, by the way, trying to say defund the police. It's like at the same time they're saying defund the police, they're escalating policing activities in a wide range of crazier and crazier contexts. So it shows that it's about power, that they're not really about cleaning up the criminal justice system. They want power for themselves and to weaponize it politically for their purposes. It's a very dangerous mindset and mentality.
Oh, and incidentally, the third police officer in our Tim Hortons case who came in, to pepper, with the guy was being pepper sprayed and arrested, wasn't wearing a mask. And
of course not.
It's like it's all. I mean, there's no word for it. It would be comic if it weren't tragic. But that's why I guess comedy and tragedy are very closely aligned. What do we want to do now? Do we want to do Michael Flynn, Sydney?
Yes. Oh yeah, Flynn. Yeah, so it was a good, well written. So yeah, the last thing on the Trader Joe's case, we'll be bringing a claim against Trader Joe's on the ADA, because the ADA laws are clear that if you have a medical condition, then they have to make reasonable accommodations for that medical condition. And here the CDC's already laid out the standards. They've already said if you have problems breathing, you should not be wearing a mask. They go beyond saying if you have problems breathing, you can opt out. It says if you have problems breathing, don't wear it. And so she clearly fit into that condition. That reasonable accommodation was what the Trader Joe's manager recognized, which was that she should be able to come in and shop. And instead of facilitating that, they facilitated her being expelled from the place and join the mob. And the second thing I'm investigating is it invasion of privacy to cast someone in fault? Is there a way to make legally actionable this involuntary videotaping of people just because they happen to be outside of their home, but they're not in a public protest, they're not a public official, they're nothing like that. They're doing something essential like shopping for food, to videotape them against their will without their consent, and then to release a selectively edited version of that tape, or the videotaping itself was selective, that creates a misleading impression for public humiliation purposes. Is the media responsible and liable for casting your name or reputation in a false light when there was available information to them, and it's just a negligence standard because it's not a public official? Actual malice only applies to public officials or public figures, sometimes limited purpose public figures. Excuse me, but only public figures. And so in that context, I think you should be able to sue, but I don't know yet. So we're going to research that possibility. But I am going to start, and then I'm getting tons of inquiries on what about suing on these masks in general. And what I've been telling people is I'm looking at ways to try to do so, but I'll be honest with everybody, it's likely the courts are not going to listen. They'll listen in the ADA context. I think we can at least discipline that aspect and make people not be mob mindset mentality, and start to publicly educate people using the suit to do so, not only businesses, but the public at large, that, by the way, there's people who, for reasons of autism, reasons of asthma, reasons of other health reasons, cannot, and by the CDC's own rules, should not be wearing masks, so that there's less of these mob mentality attacks on them, hopefully. But in terms of suing everybody else, the governments, from requiring masks, the hard part is the court systems are requiring masks. So I'm going to be going in and asking a judge who's just signed an order making me wear a mask to even come into court to say, by the way, these mask mandates are unconstitutional. What do you think he's going to say? He's going to say his own order is unconstitutional as to me? So realistically, that's a huge uphill battle. I'm going to probably bring the right case because I want to establish the right to your dress as part of your constitutional rights. I think that the state doesn't have a right to dictate to you certain things about dress. It can require that you have something on, but apparently not in Portland, because there's people not wearing a lot there. But putting that aside, but not everything. I don't believe that they should be able to form any kind of clothing Sharia law of any kind. I don't think that should be required. And so I want to challenge it. I want to establish that right, even if I don't get the remedy as to masks. But practically speaking, all the people wondering about masks, it is a very hard thing to challenge right now because almost every court system I've seen is adopting the same rules themselves.
The mask is always going to be hard because it is, whether you like it or not, it's a minimally invasive measure.
And it feels like it would work. You know, you think, I got something covering me, so that's going to keep all the bad stuff from coming in and all the bad stuff from going out. And as Scott Adams points out, there is evidence that might be the case, that it might help a little at least. But the evidence is controverted. It's far from clear, and there's a lot of evidence that it won't, and that it can be counterproductive. No, but it's common sense. I mean, when you sneeze, you block it, and when you sneeze into your arm, you divert the projectile. I mean, it's common sense. The only question is, at what point does it become unnecessary for the protective measure that it's well, yeah. The three big issues are: one, we're applying this to asymptomatic people, so that who most likely do not have COVID. So a whole bunch of people are wearing the mask who do not have it. But the assumption one is that asymptomatic people who don't know they have it really have it, and can spread it at a substantial rate. There's simply no evidence for that first assumption. The second assumption is that the particles are big enough that masks will either stop their coming out or coming in. And most of the evidence is that COVID particles are too small for a mask to stop, even an N95 mask. Definitely the case with these like bandanas and scarves and cloth masks. They ain't keeping anything out. But even the N95 mask doesn't keep out small particles. That is the predominant means they currently believe COVID-19 is spread through. And so then so that reaches the third issue of, well, what's the risk even if I get COVID? So in other words, we're basically saying you have to wear a mask for the 1 in a million chance you might spread it and someone else might get it and die from it, because that appears to be the actual math. Even if you postulate their assumptions, even if you assume asymptomatic people can spread at, say, 10% of the rate that symptomatic people do, and even if you assume that a fair number of people out there don't have it, don't know it, and are spreading it asymptomatically and are working in public, and even if it spreads by droplets, and those droplets are a mechanism of transmission at a rate of, say, 10% that the regular transmission rate is, even if you postulate what some of the more aggressive pro-mask studies assume, it all, when you add up the math, it's about a 1 in a million chance. It's like, okay, if they can mandate I wear something uncomfortable to me for a 1 in a million chance of reducing death, we'll start applying that to a wide range of other contexts. Why couldn't you just ban all driving? Driving over 35 miles an hour probably has more than a 1 in a million chance of causing some serious harm. Well,
no, but some people are going to say just apply it to any other airborne or drop.
Yeah, the flu. It's like, if we can close down schools for this, we have to close schools until the flu ends. And the flu's never going to end by any objective evidence. We've had it for every single year for more than 100 years. But the flu is more dangerous to kids under 15 than COVID-19 is. And yet we're shutting down schools in the name of COVID-19. Well, if we're going to apply that logic, then that means we can't open schools ever again. So if we were doing apples to apples and oranges to oranges, there's a lot of dangerous consequences to allowing these doctrines to come in legally. But I only want to challenge it when I think we're going to win, not when I think I'm going to greenlight a bad set of precedents that is going to turn around and be used against us forevermore. So it's finding the right case, right place to bring.
All right, amazing. And now Mark Montijo, first of all, I don't want there to be any hard feelings between me and Mark or anyone else in the chat. And Mark, he says, legalese is such a wonderful and at the same time a tongue-tied dance of actors with 50s tap shoe performers. I believe not in jazz hands, but honest chat with our neighbors. Fry, you are cool, brother. Thank you very much, Mark. Yes, it is so tongue-tied sometimes that even the people who drafted the legislation don't know what they drafted or don't appreciate what they drafted or don't take the time to see where it's going to go. And it's an interesting thing because everyone says, however you feel about masks, most people are going to do it regardless. There's going to be this 5% who people
I'll wear like a loose-fitting mask with it has a lot of American flags all over it, just to one, I have to go into court, and two, I'm not trying to upset people that are randomly out and about. So I'm not one of those. Well, I am occasionally, but I'm not all the time. Trying to socially make a political statement when I go to the store. On the flip side, I definitely dislike the mob mindset of people against the people that are choosing not to wear masks.
Without even pausing for a minute to think there might be a reason why the person's not wearing a mask. I've seen people, I don't know if it was a tweet or a comment, but someone said, I was left in a car when I was a kid. There's no way I'm putting anything over my mouth. Another person said I was assaulted. I'm not doing this. As if people have to like now start divulging that's the reason why they're not wearing one before the people get it.
I have a potential client with a mental health condition who's being required to wear it in a city. And so I'm looking at bringing suit because he was someone who's like, look, he said he's been successful dealing with a mental health condition for many years. The pandemic has already caused problems for him in trying to deal with, because his routine was substantially interrupted in ways that undermine his mental health condition. And he's like, the mask is going to, he knows it's going to make its situation worse. And that's why, I mean, this is all based on public hysteria. So I'll debate anybody, any place, anywhere, anytime on the scientific quality of masks. If the governments were confident in it, they wouldn't be afraid of me bringing suit about it. So almost any of that, the whole thing with all the pandemic is how many of these politicians couldn't justify what they did. So in most of my cases, they ultimately either settled or they changed the public policy so that I couldn't sue on that particular pernicious example of the lockdown. They realized they wouldn't be able to win on it because they had no evidence behind it. Or in the case where we went to court in Virginia, last week we prevailed. Got the court to strike down a bunch of the rules and restrictions related to the pandemic. So, but the courts don't want to strike down the whole set of rules and are very deferring to the government. And they're not doing it based on science. They're doing it based on power. They're the executive branch. All these judges that are signing this, I doubt a single one of them has a single clue. I'll give you a classic example of this. I'm in the Virginia federal courthouse arguing for limiting the number of signatures that have to be required to get on the ballot, given that these signatures are required to be gathered in person, and given that the rules don't allow people to really circulate in person anymore, and big public events are shut down. I ultimately win, but in the process, the lawyer arguing against me for the state has a mask and freaked out every time I got within 6 feet of him. He's like, I was like, hold on a second. You're freaking out in a courtroom when I got a mask and you got a mask if I get within 6 feet of you, but you're demanding that all these third-party people knock on doors and get signatures in order to get on the ballot. Yeah, the hypocrisy is incredible.
That's like the drinking the water scene out of Aaron Brockovich. I think it was Aaron Brockovich, or was it a civil action? I think it was Aaron Brockovich.
I think that was Aaron Brockovich.
Now here, Stevie says a point that I think some people are thinking, and I know what a lot of people are going to respond to. Y'all are acting like these masks are going to be a permanent thing. We're dealing with an epidemic. The shutdown isn't legal under normal law. Here's the problem, at which some people are going to say, things become permanent very quickly in the blink of an eye, and once. It's not the slippery slope. I mean, and someone said it's not a slippery slope.
I hope they're temporary. Unfortunately, what happens when they let these bad doctrines in, they first approved a kind of a mandatory vaccine. They actually approved of a fine related to it. 1905, the Jacobson decision in the U.S. Supreme Court. They then used that decision to justify forced sterilizations that continued for 70 years and caused harm to 70,000 women, poor women mostly. Then they used those two decisions to justify a mandatory draft. I've never believed the draft is constitutional. And then they used that combination of decisions to say they could take away all your rights during World War II if you happen to be of Japanese ancestry. So there's a bad history in the law that once some doctrine sneaks its way in, of it being applying much broader and much wider. And as Milton Friedman once said, there's nothing more permanent than a temporary government program.
Mark Watson says everyone just needs to start wearing MAGA masks. Have Trump promote it, then liberals will immediately want to ban masks. It is the question of if it's being justified now based on the efficacy or the efficiency of the measure. If this is the standard, it's then it's going to be applied similarly in the future.
Well, they've already established precedents we've never had before. They've already said that the executive branch can unilaterally, on its own accord, deny people First, Second, Fourth, Fifth, and Sixth Amendment rights in the name of an emergency, that the courts will not meaningfully review or second guess, that they can discriminate against people solely because of their religious identification or religious participation on that basis. U.S. Supreme Court 5-4. So they've already approved things they had never approved of before. And I am concerned that they will continue to do so. That's why I'm trying to find the right cases to push back against it. And hopefully we'll have enough of the right cases that will get that corrected. The person's right that in theory, these are temporary and shouldn't be worried about. But in reality, that's just not the way our legal system tends to operate over time. They tend to use these temporary provisions to create permanent problems.
And it's very interesting. Someone actually, Pink Sniper 28, thank you for reminding me of this, because it's not exactly what you're talking about, but what about all the states, cities that have bans on wearing masks in public? So the interesting thing is, and this is where it's good to be consistent, in Quebec, we just passed a law. I think it was Bill 21. I did a video on it about banning religious religious symbols in public, or for public employees on the job. And they banned face scarves, overt crosses. I think kippas were on the list. And I said at the time, I don't support the law. It doesn't really make much sense, because if the idea is to ban something that is overtly religious, if someone takes off a scarf but has a certain name, I'm going to know as much about their ethnicity as I would if they're wearing an overt religious symbol. So what's the next step? Banning the names, making people have non-religious names, whatever. Now the argument is they just banned these religious face coverings, the burqa, the hijab, and now they're requiring face masks in the name of this public emergency, which means when you have inconsistent laws, eventually it comes out in the wash. So there's
a bunch of states that, because of the Klan, banned masks, banned public mask wearing. Some of those laws were struck down, some were not. But yeah, it's definitely, we've gone from one extreme to the next extreme, and it's all in the name of hysteria. I mean, this is a disease right now that, in terms of excess deaths, is likely not to stand out over time. For the U.S., for example, we'll probably have a slight rise in the number of excess deaths, probably. And excess deaths is the way the medical literature used to measure pandemics. So it's how many deaths happen that would not have otherwise happened over a 1-year time period. It takes into consideration that sometimes a pandemic may simply accelerate the timetable of someone's death, but not by more than a few months. And it looks like right now, based on available data, that COVID-19, if you looked at it on an annualized basis, will probably even be just a tiny jump compared to normal years. That will probably end up with something like 30 to 50,000 quote unquote excess deaths, more deaths than normal, more deaths than expected. And, in a country that has more than 3 million deaths every year, that's not a big number. And yet in the name of that, we have people not wanting their kids to go to school, hiding in their homes, screaming at people if they walk into a store without a mask, and the rest of it. So I never thought these are some of the craziest times imaginable. Kind of fun, but crazy.
No, fun. It's scary. I didn't think it would get here so quickly, but it seems like it wasn't a drip. This was a flood, and then you'll be happy when your house only has a foot of water in it, not 30 feet. Just because your hair looks worse than mine. Mercy Gomez. So what, Mercy Gamers? So my joke is, one day I'm going to show up and surprise all of you in a suit and tie, freshly cut. I was going to do it today, but it's too hot. My hair looks terrible. So when I get cleaned up, maybe I'll do it. And that's the one thing I just want to end on. This also is, I think 95% of the people would wear a face mask without a problem. And a lot of them would disagree with it, but they would still do it just to make, courtesy, avoid conflict. 5% would be whatever the names you want to call them, will not wear it in public. As it is now, as the law which is drafted to address this 5%, as it is now, it's still not going to address the 5%, because there are going to be ways for them to not wear the mask, even if the law says they should. And so you end up enacting a law to not solve a problem. That's the one thing. The second thing is, people do need, and I hope you do prevail on one of these, so that people reflexively think, well, first of all, if 95% of us are wearing masks and this one person is not, for whatever the reason, what's the real risk? If it's a question of principle, pourquoi, as we say in French, pourquoi mourir pour une cause? Like, why die for one cause when there are so many? But then the flip side is, people should start reflexively thinking, there might be a damn good reason why someone doesn't want something over their mouth. And it might be an embarrassing reason that they don't want to disclose. And this is the world where we're living in, where there's no reflexive second guessing, second thoughts, taking a step back and taking a deep breath. It's 0 to 100 if someone's not following the law. And that's another part and parcel of the problem that comes with more laws, less justice. I'm going to follow that Trader Joe ones. When the proceedings are filed, I might do a vlog on them. I think I'll know where to find the proceedings.
Exactly. I hope to file it this week. To get it out of the door. And when you add to the craziness, you have those people just trying to protect their right to shop in the store within a manner that's healthy for them, as identified by the CDC and run out by the mob. The other sort of mob rules logic that's taking place. Then you see the same thing with the Missouri case. The Missouri case really the mob gets to rule, and if you try to defend yourself against the mob, we're going to criminally prosecute you. That's the Missouri message that I see being the takeaway. And then we have Portland, where now they are suing. The state government is suing to prevent the federal government from enforcing federal law to protect federal property. Apparently, everybody missed Mississippi Burning, the movie, the 1960s, the civil rights movement. George Wallace, you don't get to stand in the schoolhouse door. You don't get to allow the mob to take over your town every night for more than 50 nights in the city of Portland, waging war and deliberately targeting federal property, by the way. They've been going back to the federal courthouse every single day to attack it every single day, wanting the feds to come in. They're hoping Trump would send the tanks in. And instead, Trump was more restrained than LBJ was in 1968, more restrained than Poppy Bush was in 1992. And by the way, there's a great documentary on the 1992 riots in LA by National Geographic that you can find actually on YouTube for free. What's fascinating about it from a cinematic perspective is they have no narration. All they do is string together interviews and videos of the time period. Nobody narrates at all. There's no interviews. There's just, I mean, there's interviews they put in there, but they're interviews done by other people at the time. So you get a real contemporary feel, which is fascinating. Fantastic review. If I was defending the Missouri people, I would list it as one of my exhibits. Of course, in my criminal tax trials, I always list Alice in Wonderland as one of my exhibits, to squirrel around with the government a little bit. I want to make them read it. Yeah, because most of them haven't. They need to remember what the world is like. But you actually have a state government suing even Alabama and Mississippi didn't think to do that in the 1960s during the Civil Rights Movement. They didn't think to sue the feds to enjoin the FBI from investigating their local corruption, or the U.S. Marshals. People forget it was mostly U.S. Marshals, their U.S. Marshals Service, protecting people going into those schools in Arkansas and Mississippi and Alabama. What has happened in Portland is the Department of Homeland Security, which is the agency charged with protecting federal property, has created a task force with the United States Marshals Special Forces. And the U.S. Marshals have a lot of special forces to protect witnesses, to protect judges. They're to respect federal officials of a wide range. They are the ones in charge of protecting federal courthouses. It's other U.S. Marshals that have already died, like in Oakland, because of these Antifa attacks on federal property. So they, combined with DHS, combined with a few other federal agencies, are working together to finally try to put down the daily, nightly rioting in Portland. And the response of both senators, the response of Speaker Pelosi, the response of the Attorney General of Oregon, of the governor and the mayor in Portland, is to bring suit and to publicly attack this as if it's the Stasi Secret Service. They're calling it Trump's secret police, and unmarked cars and unidentified uniforms are grabbing peaceful protesters off the street and throwing them into vans to disappear them inevitably and inescapably. And it's like, okay, I'll guarantee you that's not happening right off the bat. But I follow and track conspiracy theories because I find them interesting, and you'll always find a kernel of truth, at least in some of them. The first surprising, shocking truths will be somebody you ignore as a conspiracy kook. Somewhere in there, he'll have a little kernel of truth that actually reveals a truth that no one else is talking about. So I track it for a lot of reasons. Also, as a fun hobby. I had no idea some of the conspiracy theories the left believes. They believe that, like in Chicago, 7,000 people have disappeared over the last 2 years by secret police kidnapping them. It's like, okay, this is not happening, my friends. This is not Argentina in 1970. And so that has apparently been the mindset and mentality. The whole media jumped on this as this somehow is terrible. Federal law enforcement enforcing federal law to protect federal property. It's been the established. We fought a civil war to determine who gets to rule. It turns out the feds do. That's been established since 1865, when the South conceded. Apparently, Antifa didn't. So I guess there used to be a bumper sticker in the South that said Robert E. Lee surrendered. I didn't, which I always found funny. It's like, you're here in the States, pal. You already surrendered. You just don't know about it yet. But apparently, it's going to be Antifa's new bumper sticker. Robert E. Lee surrendered. Antifa didn't. This is just insane. It's a suit that should go nowhere, but you never know with the federal courts these days. So if they get an Obama appointee, he may decide that he can weaponize the federal court system, just like Judge Sullivan's doing in the Flynn case, which maybe that's our transition to that. And the rest.
I got a text. The kids are coming back soon, so our quiet time might be over. There was one thing that someone said. We talked about the event with the judge's family. So Dwayne, at the beginning of the video. Do you think Trump timed it right, waited long enough that people are glad the feds for now? A lot of people are hypothesizing. This is why it's the damned if you do, damned if you don't. If Trump intervenes right away, they blame him for overreaching federal authority.
It's a net win, my view, no matter when he intervened, because two things. History says, what I'm telling my lefty friends, I was like, I've seen this script. Go back and watch 1968. Watch the documentary on the Weather Underground, which is also very good, how they went completely crazy. We know how this is going to end. Watch the Black Panthers documentary. The radical left is not popular. Attacking police over time is not popular. The net effect of this will be a massive backlash. It may not show up in the polls right away, but it will be there come election day. And if you're Trump, you're also changing the story. So as long as the pandemic is a dominant story, that's a net loser for Trump, no matter what he does, because he's just not. A pandemic invites a nurse-type personality. It's meant for Democrats. It's not meant for Republican. Definitely not a Trumpish Republican. The pandemic is, he's not soft and feely. He's not. What about the poor elderly people? That's just not who he is, even if he wanted to be. On the other hand, Law and Order is right up Trump's alley. And there, if they're going to choose between, the more there's talk about Portland, the more there's talk about Seattle. Trump's always understood if they're talking about me, I'm winning. And if they're talking about the issues I want them to talk about, I'm winning. And that's why he'll often trick the media into covering some issue he wants to cover by misspelling something. It's like every time he does it, or by being over the top. He exaggerates. And so they jump on the issue, but he wants that. He knows that topic is a winner for him. Who the country's going to feel safer with is going to be a Trump winner, no doubt. It's not going to be Uncle Joe or the Democratic Party. So the more he highlights Portland, the more he highlights Seattle, the better for him. So he could send in the troops and they'd be okay with it. That the ordinary person out there is not afraid that the troops are coming for them. They are afraid increasingly that rioters and looters and the BLM and Antifa types might be coming for them because they're seeing it happen in social media where they can be randomly targeted. They're seeing it happen in their local communities where they can be randomly raided. So in that context, any action Trump takes is a winner. I think he's actually been, I'm glad he's been reluctant because I personally am not a fan of a lot of U.S. military involvement at all in our domestic law enforcement. But that's a personal view. Politically speaking, the more involvement he has in that respect, the better. As a objective political decision. It's just not one I would prefer be made because I would like us to maintain as little military involvement and as possible.
All right. Interesting. And now I just realized that my hair is grayer on the sides than it is on the top, or maybe it's just the lighting. One question actually before we get into the other one. Corliss SD says, for Barnes, are you still doing the American Countdown podcast? And what is your pro bono outfit named?
So yeah, the pro bono group that I started, run by other people, but I still do a lot of work for them, is Free America Law Center. So freeamericalawcenter.com. You can go follow, track. Going to get a newsletter up and going. Have made podcast available, some exclusive to them, or at least priority to them before it's released to everyone else. In terms of the countdown, American Countdown, right now it's on hiatus. I may bring it back Labor Day. May bring it back before then. Practical realities, I had a lot of legal work come up, and so I didn't have time to record the last 2 weeks or so. I may get back up and doing it. I go back and forth on how I'm going to utilize it. And it also depends on there's some third parties there who have their own ideas about when and where and how to bring it back. So that's sort of on hiatus for the time being. I do hope to have something up and going, but right now the primary place you can find me guaranteed weekly is Viva La Barnes.
Booyah. And now people are getting antsy for the Flynn.
Yes. Great response by really great response by Sidney Powell. I thought it was an even better brief than what she filed in her original writ. I thought she was really on top of her game. The government's response that came in later today, I thought was weak. But her response was very good. And she highlighted a couple of big things. And one of the big things that stood out to me was that Sullivan really does not have standing. She made a good argument on this, that while the court can order Sullivan to respond, Sullivan is not a party to the litigation, and as such is not considered one, even though the writ is issued against him. And she pointed out the only time any other judge has ever claimed the authority to seek a petition rehearing en banc related to a writ of mandamus, the Second Circuit Court of Appeals said that the judge has no such authority to ever do that. And since there's no ongoing controversy because both parties have resolved it, and because the judge is not a party, her point was that this writ has to issue, and the petition for hearing has to be denied unless the courts are going to endanger their own jurisdiction by exceeding it, by allowing judges to declare themselves unilaterally parties. So I thought her brief was really well done. You can find it. They've made it publicly available to people. Both Molly McCann, her associate, and Sidney Powell have made it available for people to find online. I read it earlier today. Very well written, very well crafted, to the point. And she likes her baseball analogies, I think, because baseball season is starting. And she knows that disproportionately It's one of those weird things, but lawyers and judges are disproportionately baseball fans. And so the consequence of that is she used a lot of baseball analogy, and her great baseball analogy she kept coming back to was, and I always recommend people to use visual analogies and metaphors because they're Scott Adams makes the same argument because they're much more powerful forms of persuasion. They help people connect what can be an abstract issue into a concrete, visible one. And her point is that what the judge is in a federal criminal case is the umpire. And just because on occasion he might get put on first base, like a court asking him to respond to a writ, does not mean he gets to run the bases, pitch, go out and field the ball, or go and hit. And that's what he's claiming he has a right to do. And it's time to return him to his umpire status. The game is over. Shut off the lights. Let the players go home. And so I thought it was very well done.
I would have gone with the Kevin Nealon analogy, put the ball in the hole, but that might not be applicable. So incidentally, someone sent me the brief, and I have to thank him. He's on Twitter. It's Jimmy Deleeu, Deleeeuw. So at Jimmy Deleeeuw. That is not an endorsement for anything that might be on this person's Twitter feed. He just messaged me the brief because he said do it, and I got it. It's a good brief. The problem is, at this point in time, 90% of it has already been pleaded. So the brief goes through the facts. It goes through the evidence that Sullivan ignored, that Gleason ignored. The novel argument that the brief raised was the lacking of standing, which was the first time I heard it. And it did surprise me because the judge is the object to some extent of the mandamus. But people need to appreciate this, that it was Judge Sullivan himself who petitioned for rehearing, not any of the judges of the Court of Appeal, not the dissenting judge on the decision, who all could have. So nobody. And
I think she's right that, well, put it this way, there's no precedent that's ever allowed it. And the only judge who ever tried that was a judge who was ordered to be reassigned from the case by writ. And she filed a petition for rehearing before the Second Circuit. And the Court of Appeal is like, no. You have no authority here to do that. And it's like, well, I don't think the courts of appeals want judges thinking that they should be parties to cases. So I think that what it is she gave them another policy reason to get rid of this, to say, okay, we don't want to start greenlighting judges starting to feel like they're just roaming prosecutors, roaming litigants. They get to, that's not what we should be doing. And she did a great job pointing out how many factual errors the petition made. And a good one that I really hadn't quite seen fully articulated yet was she points out not only legally does a guilty plea not constitute a conviction, and the petition mistakenly said that Flynn had been twice convicted of this crime. But secondly, she pointed out, well, also, but a little tangential point, she found another case where Judge Gleason, when he was a judge, had been hammered by the Court of Appeals for thinking he has more power than he's supposed to. And he's the amicus that got assigned the case. When I have somebody like that I want to tweak, I always find one or two places I can tweak them when I can in legal proceedings like this. And so I give Powell credit for finding something she could tweak him with. But the other point she made was that probably neither one of these, and this would impact there couldn't be a perjury prosecution anyway, given the way perjury law is defined. But she made a good point. There was probably no actual plea hearing that ever was conducted in this case, because the first one was done by a judge who had to recuse himself, which meant he never should have conducted the plea hearing in the first place, which Judge Sullivan seemed to implicitly recognize by holding a second plea hearing. And secondly, Sullivan cut off that plea hearing, never finished the constitutionally required colloquy. So that plea hearing was never finished either. So her point was there was never even a full plea hearing here. So all we really have was an attempted plea that was never part of a finalized plea because it never met the constitutionally conforming standards for it. So I was like, I hadn't thought about it that way. That's an additional point I'll make in the future, that what you really had was a contract between General Flynn and the government, that he had a right to revoke that contract, because that's all a plea agreement is, a contract. And then we use contractual laws to enforce them. And he had a right to revoke that contract because he was misled. It's called, fraudulent concealment is one way to put it. Fraudulent inducement in the contractual context. He was fraudulently induced into that contract due to the bogus advice of his conflicted counsel, undisclosed conflicted counsel, and due to the government withholding material information pertinent to that contract. So that's all that ever happened. Otherwise, he never really swore under oath anything that was part of a final plea proceeding because the plea proceeding was never completed. So I thought that was actually a useful point that she made, not essential to to these proceedings at this stage, but useful for public legacy purposes.
Yeah, it's interesting. The only problem is it might be somewhat sufficiently nuanced that the public might tune out.
Oh yeah, I think a lot of what you can legally say is anybody who says, "Oh, Flynn pled guilty," you can say, "No, he didn't." Legally, he did.
Now the question was, first judge. Remind me again why that judge recused himself.
They've never fully disclosed, but it turns out he had personal relationship with Peter Strzok. And he was involved in some of the bogus FICE applications. So
Okay.
the guy was neck deep in the corruption of the case. And apparently Strzok had made suggestions that he could make sure that judge ruled their way. And so his internal communications, that guy's the gift that keeps on giving. To all the criminal listeners out there, remember, never in writing, always in cash.
And speaking of cash, Bacon Seed, thank you very much for the super chat. I hope you didn't mean to. I don't hope you didn't mean to make a comment and didn't get it in the super chat, but thank you very much. Regardless, so I didn't read the government's brief. In a nutshell,
the government basically reinforced the same thing, but they should have been more aggressive on the fact that the prosecution was bogus. They don't want to admit on the record that it was a bogus prosecution. They're like, we had reasons to reconsider, and we don't believe our internal decision-making should be invaded by this judge acting like part of the executive branch, like a de facto inspector general. But they wouldn't concede that Flynn committed no crime, and they wouldn't concede that the prior prosecutor did anything wrong. And I get why. They never want to admit that on the record. But at this point, they should have. It's obvious he did. And to continue to pretend that the former prosecutor was anything other than an unethical prosecutor who used illicit tactics in violation of the Constitution to try to secure a false confession and conviction is not being fully forthcoming to the country. And it is a worrisome sign about the direction that Barr and Durham are going in. Durham is now promising a report by the end of the summer. I can tell you from my experience, if anyone was going to be indicted, we'd already be hearing about it. Just look at Mueller by comparison. Mueller was very quick to bring grand juries, very quick to bring search warrants, to bring litigated subpoenas, and very quick to bring indictments. You heard about those months in advance of those indictments. You're not hearing anything right now. So I think that they're going to brush it under the rug until after the election and see if Trump gets reelected or not. And so I think that's problematic. But like I said, with Barr, I'm skeptical. I hope I'm wrong, but he's gonna like the state of Missouri. It's supposed to be a show me state. Apparently, you just can't show them your gun if they're trying to raid your house. But I'm a show me person when it comes to Barr.
Yeah, I was sort of just hoping that both sides have different methods of doing it, or thinking, not hoping. But maybe they have different methods of doing it. One side leaks more beforehand, and the other side tries to hold things tight until.
Well, usually these leaks come from defense lawyers. Is what a lot of people don't know. A lot of these government cases, the leaks are the defense lawyers leaking. So the defense lawyers or people connected to them are the ones leaking to the press. Usually as a way to, like I suspect Peter Strzok and Comey had been making public statements over the years as a way to tell other people what to look out for. That's how they do it. So that's often why you see leaking. I've never leaked in a criminal case I've ever been a part of, but I understand why other lawyers do, because it's making sure certain people have a heads up.
Amazing. I think we did a good job. We did we miss one, which was the Portland lawsuits? I think we got to everything, right?
Yeah. Just those are crazy lawsuits trying to stop the feds from enforcing federal law. Because, by the way, everybody, if you're a cop, you do not have to identify yourself as a police officer. You don't have to tell the person you're arresting the probable cause for the arrest. That's an arraignment issue, not a arrest issue. You have to actually have probable cause when you arrest them. You don't have to tell them what it is. Undercover operations are routine. That's nothing abnormal. There was a super chat, I think, towards the beginning that asked about what about the guy that got picked up and was never charged? They do that all the time. So I'm not a big fan of it, but as long as they had probable cause at the time they arrested him, the fact, that's all that matters. So for example, that guy can bring a Fourth Amendment suit. And here's the thing. We'll find out. That guy put his name on the record. We'll find out if that was legit or just a PR tactic. Because if he was truly picked up for no probable cause, and he knows they have no probable cause, then he'll bring a federal civil rights suit. That's easy. That's like 10 grand, 20 grand in damages and plus whatever your legal fees are. Now it's a Bivens claim in the federal context. So your fees are not always recoverable and things like that. So it's not always as open and shut legally from a damages perspective, but you'll usually bring a suit if you've been picked up for no reason. My guess is that person never sues because there probably is a reason. Antifa knows how to gaslight the public and get their media allies to gaslight the world. That's why you get people who are really convinced that the Klan is a big, dangerous thing when it hasn't existed for decades, and that Antifa doesn't really exist. It's an extraordinary level of gaslighting that is contra what anybody studying the evidence. Like someone that would say, "Oh, Antifa isn't made up." And that's like you do realize they've been around since 1929 in Berlin, right? This is actual organization. Here's all their own documentaries. They want to let you know they exist. I mean, just because Will Sommer at the Daily Beast or Sebastian Murdoch at the Huffington Post or some of these political hacks that want to pretend something doesn't make it true. It showed me that when Nancy Pelosi is out calling federal law enforcement stormtroopers, it's 1968 all over again. Even then, the Democrats knew not to go that far. That were institutionally connected.
No, I said this in a tweet. Like, if that's not a threat, I don't know what is. And people are like, well, why is it a threat? See, when you demonize the president and then refer to his police as stormtroopers, and how do you fight evil in the movies? And the movie that she's referencing, I don't know how anybody can see it as anything else when you are just you're feeding wishes to people who you hope might do something crazy.
You're telling anybody with any law enforcement power, even private citizens, that if they enforce the law in ways you don't like politically, you'll take retaliatory action against them. And you're seeing it all across the board, whether it's the Circuit County prosecutor in Missouri, whether it's the DA in Manhattan, or whether it's the mayor and the governor, the mayor of Portland, the governor of Oregon, the two senators from Oregon, or the Speaker of the House of Representatives. Number 3 in the line for the presidency of the United States.
Just one question as a matter of fact. In Portland, are they're unmarked or undercover? Are they identified by any identifiable enforcement?
They're identified as police. So what is their names are not being identified, and the vehicles are rental cars rather than. The reason why they do that is because the way Antifa operates, they keep a lookout for police. So these guys wore camouflage and were in rental cars, and so they don't see the rental cars coming up until the last second. And then they're grabbing people and then taking them and interrogating them. And some they're arresting, some they're releasing. And Antifa's unaccustomed to that strategy. They wanted public confrontation. They wanted tanks. They wanted the political people to be lined up against them. That's why the next night they brought in pregnant moms. I don't know why pregnant moms are doing this, but hey, to be their like front line of defense. I mean, the fact they've been committing violence, it's like there's people all across the political spectrum have been putting up videos now for 50 days. Everybody could watch it every single night. They're attacking property every single night. The only question is whether they attack people. Sometimes they did, sometimes they didn't. But they're attacking property, and all of this was lawless. You do not have a random First Amendment right to take over city streets. You have to file a petition, get permission. These groups have not. These groups, or at least in general, have not. They're just taking over whatever they want, wherever they want, however they want. And they've been targeting federal property. They've been destroying statutes, destroying other forms of property, trying to break into the federal government, the U.S. courthouse, which, by the way, I wouldn't recommend. Those marshals take that stuff very seriously. So once a marshal went down in Oakland, those marshals were not going to take any crap. Probably the most aggressive people they're going to find out over time were U.S. marshals, because these guys are just they're very aggressive, and they know what they're doing, and they don't take anything. I mean, I saw a federal marshal threaten to arrest a bunch of people in my case in Virginia just for not sitting 6 feet apart, just because that's what the judge told him, and that marshal was they're hard asses. So the idea that these are probably mostly marshals, but there's really no legal basis for this injunction. But you never know with Obama courts. But the case shouldn't go anywhere.
Let me get to this question, because it's a legit question. If they don't have to identify themselves as a police officer, how do you know it is an officer and not someone trying to kidnap you?
So two different things. They do identify themselves as police, and they're often identifying their agency. They have police on their badges and in the back of their uniforms. Beyond that, you don't have to identify yourself individually. Now, if you reasonably believe that someone is not a police officer, you can defend yourself. This is a common problem in warrants. It's one of the reasons why they don't like no-knock warrants. Breonna Taylor case in Louisville. Though actually they got a no-knock warrant. Apparently they didn't actually use it. They probably should have, because had they used the no-knock warrant, she's probably alive. People don't realize that it was. I have a case in California where they raided the wrong house and terrified a little girl. And if they had done 5 minutes of proper pre-warrant surveillance, they would know they had the wrong house. That wasn't Breonna Taylor. They had the right house. I think it was her boyfriend shot back, because they went and did a knock, then came in, and because they didn't do a no knock, he was able to get his gun and shoot back, and then they fired back and killed her. So that case is not quite what BLM has made it out to be. BLM only likes bad cases. That should be the first part of BLM is bad cases. That's what the B stands for. They won't touch my case, which is a clean case, neat case, because that's who they are. So all they have to do is identify themselves as police, and their uniforms do identify. They have police on it. Now, if you reasonably believe, I had a case where Oakland, these guys were in the alternative product distribution business, unlicensed product distribution business. Quite good at it too, by the way. I only handled the wife on the tax issues. But they got raided, and their first response was they were weapons, guns, ready to blaze, but they held everything chill to make sure everything was right because there had been a history of invasions of homes with people pretending to be police. So it's always a risk. And just wearing a uniform. I mean, the guy who showed up and shot the judge's husband and the kid showed up in a FedEx uniform. So a uniform, you can get a police uniform relative ease.
And it's with our shooting in Nova Scotia, the guy had stolen a police car and a police uniform, and
there's no guarantees there. But in terms of what they're legally required, they have to identify themselves as police. They just don't have to identify which police department, and they don't have to identify their names. And they are identified as police on all their outfits. So there's always a risk, though. You're being picked up by someone who's not police. If you have a reasonable belief, you can actually resist, and it'd be lawful resistance. I don't recommend that because if you're wrong, you're screwed.
All right, and let's end it on this question because I hear noise upstairs, and it's only a matter of time before it spills downstairs. I think Rosa asked another question along the same lines. If it's illegal in certain states to have the two-party consent states, how can you have a recording of somebody without their consent in public? And if I can't use a photograph of someone without a model release, how can I use a video recording? This one, I think it's a difference between using for commercial purposes and posting online. But good question.
Well, yeah. Interestingly enough, I mean, it's inconsistent, really, in my view. Now, so generally that's surreptitious recording, though not always. But they're right. There's a lot of states that are one-party consent laws where only one party has to be a consent. And even in there, most of these people that are taping are not even parties to the conversation. So I do want to research whether or not that is a violation of the consent requirements for being recorded. Mm-hmm. Generally, that recording has been assumed to be referencing confidential, where you have a reasonable expectation of privacy. That's normally been the rule. That's why they've said if you don't have a reasonable expectation of privacy, you can typically be recorded. So that's where they're prosecuting the Planned Parenthood, the people who uncovered issues with Planned Parenthood, including the selling of baby parts. The people who went undercover to get that are being civilly and criminally prosecuted in the state of California on the grounds that they did not have consent. California's a two-party consent state, with some notable exceptions. If someone's trying to extort you, you can record them without their knowledge. I've done that in cases. I had a prosecutor threaten me. I was like, no. My client was being threatened with extortion. He didn't even know that was an exception to the law. So, not atypical, sadly, with California prosecutors. But just one of my random pot shots at California prosecutors. Kamala Harris, still being the dumbest lawyer I've ever dealt with in court, who's now looking kind of unique. I think she went to Michael Jackson's plastic surgeon. So,
you know what? You remind me. I'm putting a Twitter up. I don't think anybody should be making fun of anybody's face, regardless.
Agreed.
It is. I noticed it, but there's so many pictures also that are slightly photoshopped, and that's where I would call them doctored as opposed to doctored.
It also may have been a lighting issue, and I think what we're seeing with all the media celebrities is that they look a lot different with Zoom than they do. And like I said about judges, a lot of judges, like, man, they're a little more casual when they know nobody's watching and they're not in front of the courthouse. God bless them. I don't have any problem with it, but it's been interesting to witness. So we'll see how that unfolds. But yeah,
All right, I seem to have missed Sage a 4-win super chat. If you can, we got like 2 minutes left in this. No, I'm saying for the people who genuinely believe that Kamala Harris is not Kamala Harris and it's a lookalike who doesn't look enough like her, then I understand. But these people, a lot of people are just tweeting these images which are slightly modified with colors, slightly stretched, and then they look demonic in the picture. There was one, I forget who it was, and I called up the person. I said, that picture's clearly photoshopped. The color's off to make her look dead. It was, but
There's been so many of those.
Anyway, so
that
that's
reminds me. There was someone who was like a semi-credible journalist. But to that super chat's question, I am going to investigate. That's a very good question. How do consent recording laws apply to these recordings? Normally, my recollection when I researched it before was you had to have a reasonable expectation of privacy before you could sue for being videotaped, or audio taped, and that conversation being publicly leaked. But that at least forms a possible predicate for legal action. Actually, on a side tangent, I had someone who's like a connected media person who believed that people were being replaced all the time. So that, like a lot of like that wasn't really Trump. That really wasn't this person. They already kidnapped him and killed the real one, and that's the replacement. So it's fascinating. These, especially on the left, they believe things things they would mock Alex Jones for. They go far past Alex Jones on the left these days. Because like when I made the comment, I didn't think necessarily the Epstein judge was necessarily, or the judge in not the Epstein case, but the Epstein connected case, that she may not have been the target, given it appears to be a professional hit, or at least has evidence of it or indicia of it. I had lawyers responding and saying, you're just covering up for the fact that Trump had him whacked. And I was like, yeah, I don't think that's probably the case here, but I was like, wow, I was like, and you people are going to get mad at Alex Jones for conspiracy theories? Well, it's like, that's wow. I mean, at least Alex Jones conspiracy theories have had in the modern era much more truth to them than a lot of the left has. I mean, it turns out Russiagate was a pure hoax. So I like Alex personally, but the left has gone way off the edge in what world they exist. But the latest incarnate, it was a left-leaning journalist who's been trying to tell me for 3 years that a bunch of people were replaced. And I'm sure that's probably the Kamala Harris theory, that because she's replacing, that means she's going to be picked by Biden to be vice president because she's actually a robot controlled by Silicon Valley. So who knows?
Well, and without demeaning the belief, everyone is entitled to their beliefs.
Oh yeah, anything's possible in the modern age.
Stevie wants to know if you can hang out after I go be a good father. Oh boy, there's gonna be 3 kids who are staying up way too late this summer. Now, I wanted to see if I could get to Sage's comment before we closed, but I don't think I see it yet. Let's just see. Barnes, you stay. Viva, go get that squirrel. The one that stole your GoPro. People, if you haven't seen that video, squirrel GoPro Viva.
Did the squirrel actually steal it, or did you plan it for the squirrel to get it?
Well, I tied food to the GoPro.
Smart man. That was good. That was fascinating watching what the world looks like through a squirrel's eyes.
And like they're nimble in the trees. I got one version where the squirrel was going through the branches. It was like parkour for a squirrel. It was amazing.
Yes.
But I am the happiest with the fish off the drone videos. Those are just they make me happy. Okay, so I don't think I got to Sage's question. Oh, let's see. We got Buddy says, real talk, war with China, or do you think Trump has the wherewithal to destroy them with economic repercussions?
China's got 100 problems. China's not likely to go to a real military conflict. Still isn't there from a military perspective. Still depends on a lot of U.S. connections. The thing with China is they have a lot of conflicting internal instincts. They have Hong Kong's rebellion that they're trying to suppress. They have, there's obviously the Uyghur group of, I'm not sure I'm pronouncing it right, but the group of Muslims that they clearly are putting on trains and isolating. There's real religious dissident groups that they've been suppressing and oppressing for years. The publication, the Epoch Times, is based on that group of people. They've been harvesting and selling organs illegally and illicitly for a long period of time. I think they're going to put a lot of effort into having Biden beat. There's going to be real foreign interference in the 2020 election. It's going to be by China trying to help defeat Trump. Because they see Biden as very manageable and they see Trump as a real threat. But they have huge problems. They have there's some interesting YouTubers that go around documenting how there's just been massive real estate boom in China. That's all because in order to get married and due to the lack of women, due to the one-child policy producing disproportionate men have to have multiple homes in order to get married. So they're building these crap homes on crap ways that are falling apart, incentivized all kinds of they basically created a massive real estate bubble, but not just a massive real estate bubble with tenements that make the 1920s New York City look like the pride of architecture. So they've got all kinds of internal problems, currency related issues. So they're just trying to stay afloat. Unlikely we'll get in any military conflict with them. They do use North Korea as their bulldog. So the threat of North Korea nuking people is what really keeps people at bay with China. North Korea is really an extension of China's foreign policy. They're not acting independently. They depend almost entirely on China just to survive for food. And so I think that's the back. I don't think we'll go to war with China. I think that's a very low chance. I think the economic and cultural conflict will continue to rise because it's either the Chinese model or the American model moving forward. And the left has shown sympathy both with big tech and Hollywood and NBA and other cultural institutions with China. Happy to embrace China. Happy to embrace the surveillance society that China would dictate. Almost all of our responses to the pandemic have been inspired by China. That's another one of my rules. If China did it first, we should not do it second. But we have generally, whether it's lockdowns or masks.
It's a good rule.
So we'll see.
All right, and then we're going to end it with these. Jason Ridger says, the twist ending to the Flynn movie is Sullivan an ally, as the longer the delay, the more Brady material is revealed.
They can release that material under FOIA once the criminal case is closed anyway. So they don't need that case as a pretext to do so. I know a lot of people on the Q side of the equation thought Sullivan was a secret ally. I do not.
All right. And STFUFFS, I addressed this question at the beginning, and I may be wrong. I don't think I'm wrong, but I may be wrong. But I don't think I'm wrong. And now, Sage said, Barnes, are you interested in taking any Second Amendment cases, and are you willing to enter into that side of civil rights law? That is what Barnes is, just for everybody knows. Mm-hmm. Although I think, Sage.
Yeah. Well, I took, before all this craziness in Portland, before the craziness in St. Louis, I took on appeal a guy by the name called Laugh at Libs is how he's, I think, on YouTube and on Twitter. He's on the Asperger spectrum. Little guy, had been beaten up and assaulted by Antifa types, related groups in Portland, for filming them and showing them in ways that people could laugh at them. And they were threatening him on a march. There was a big group of them coming at him. He's a little guy. He had, after he got beat up, he had learned to defend himself, took self-defense classes, got a weapon, got a gun, even under Oregon's restrictive laws. He saw this huge group coming at him. He's backing up, pulls out the gun in the way he was taught, brandishes it and shows it to them, and then puts it away and steps back. He's the one who got charged with 17 crimes. He had a bad trial defense, in my view. They waived a jury trial because the jury pool was so contaminated. That was a bad idea. Judge was always going to convict, in my view. Judge convicted. We went to the Court of Appeals. The Court of Appeals found excuses to say, okay, we have a petition for rehearing pending before the Court of Appeals. We're going to be taking it to the Oregon Supreme Court, then to the United States Supreme Court. And that's the current Second Amendment case I have. But I'll take Second Amendment cases anywhere. I take the Missouri case. I take other cases because, in my view, it's a right of armed self-defense. It was the democratization of the use of force. That was the point of it. In fact, the idea was that we wouldn't even have a federal army. We wouldn't even have a federal police force. That would be the local community who had the skills and training to use guns. I've always preferred the elder system of justice, whether it's civil or criminal, that's borrowed from the Native American tribes. And that's in my view what the jury system is when best used. And in my view, that's what the Second Amendment was originally intended as. So I'm for a robust Second Amendment protection and bring suit anywhere and everywhere on it. The only cases I skip is when some guy says, I was convicted of child porn. Will you help me get my gun? No, I'm going to pass that case. So those are the only cases I pass on. And there's certain cases, if you've been, if you got a problem with certain areas, don't call me, call someone else. But Second Amendment, I'm happy to take that call.
And on that note, we're going to end it. This has been a good one. Everybody, thank you very much. As always, sorry if I missed some of the super chats. It's been amazing stuff. We're going to have more to talk about next week. Stay civil, stay safe, stay healthy, stay sane, and try to take all of this with en passant, as we say in French. Robert, thank you very much, as always.
Absolutely.
All right, stick around. We're going to say goodbye afterwards. Everybody else, I'm going to put my finger to the screen and say peace.